Tonight. Delightful. Thank you all for coming out. Right now we are dealing with 7:06, which means I have blown our agenda already. So we have a call to order at 7 p.m. tonight on a continuation of a public hearing on a petition filed by the Point Nantasket. Yeah, thanks. On the Point Nantasket Realty LLC regarding property at 839, 843, 845 Nantasket Avenue, map 12, lots 106, 108, 109, 110, Hull, Massachusetts, which, as stated in the application, seeks to review a decision by the Town of Hull Planning Board to deny a request for site plan review, I guess pursuant to section 410-4.1C6 of the Hull zoning bylaws and MGL chapter 48 section 8, and appeal the decision of the building commissioner in denying the building permit, article 1 section 410-1.C1. A building permit cannot be issued for projects which site plan review approval has not been issued. And for those on TV and those who are here tonight, going back in the Mr. Peabody's Wayback Machine, we were here just a short week ago where we heard the petitioner provide their case in chief, for lack of a better term. Again, voting on this matter is myself, Ed Parsons, and Tony May. Alternate members here tonight are Rebecca Rogers and Phil Ballone. So, without further ado, I don't know, council, have you guys reached any weird secret handshake agreement about tonight, or
We have not, Mr. Chairman.
Okay, anything new to report?
Chair Hennessy, just for the record, my name is Adam Brodsky, and I represent Point Nantasket Realty LLC.
Yes, sir.
And I will be joined shortly by Tom Fleck, a principal of the LLC, who attended the meeting last week. And I corroborate what Attorney Winters, we have not reached any agreement. It's my understanding that the planning board would be afforded an opportunity to present its case. Then you did offer rebuttal. I don't know what rebuttal we will provide. I did send to the Zoning Board of Appeals a letter yesterday, which hopefully you have all received, with the information that I contained in my rebuttal. And then you had mentioned closing. I don't know if that's necessary, but when we get to that point, we'll see where we are.
Yes. Thank you, Attorney Brodsky, and Attorney Winter, thank you as well for both being here. Do you want us to sort of park this for a second while Mr. Fleck makes his way up to the room, or are we good?
No, please.
Okay. So for those who kind of bummed, less crowd than last week, but such is life on a beautiful Tuesday evening in August, is that yes, what we were appreciative of all that the applicant had to offer last week in a fairly lengthy hearing, and because of that, we want to afford the planning board folks to be able to have the same amount of time to present their position as it relates to this site plan review and the May 19, 2026 decision that we're here for tonight.
May 19th decision, May 14th.
Well,
meeting.
thank you, Rebecca. I actually said May 19 decision, but
Yeah.
I mean, yes.
You're correct.
Yeah, okay. So, but I appreciate everybody checking and balancing me as we proceed tonight. So just as sort of an opening observation on things is that, yes, Attorney Brodsky, I'll acknowledge the receipt. Forgive me, I deposed somebody for 5 hours today, so I didn't have the time to sort of digest the whole thing kernel by kernel, but I will acknowledge receipt of what I believe to be approximately 214 additional pages of information. One of the things that I wanted to get out in the open is that, with all due respect, I have issues with factoring in that information. I get the mission behind it. I get that you're referring to section 101 or 103 of the rules of evidence. I understand that completely, but as it relates to what we're here for tonight, I think, and this can be dealt with in conjunction with our conversations with our attorney, like the next phase of this, right, is that the way that your position paper that we received today, it's more, there are other issues in it, but it's more of like a rebuttal to all sorts of things to come, right? So I would prefer that we not address those things, because my concern is that a lot of the information is outside of the scope of our review tonight. But I will welcome like a repackaging of that submission as it relates to any, closing arguments, to the extent that there are going to be ones, either, oral or written. And then that begs, the issue as to, how we proceed tonight. So I guess we should play it as it is and see how the planning board presents. And if there's, time in the evening, I want to give you all the time in the world, equitable to what Attorney Brodsky had last week. I'm certain there's going to be a bunch of questions from myself and those voting on this matter tonight. So let's sort of take it as it comes, and without any further issue or questions from you guys. And also, just for those who are here who weren't here last Tuesday, forgive me for not remembering everybody's face, but just to remind the folks in the audience, and this is more, and as well as for the people who are watching on TV, is that our charge tonight is beginning last Tuesday and continuing tonight, very narrow. It focuses on how we got here, in the sense that how we got to this planning board decision dated May 19, 2026, and the record below that led to that decision, to include hearings and all these different kind of things. During that separate proceeding, obviously there was a great deal of public comment, which was part of the process. Tonight, I get it that there's, less numbers, but probably no less equal passion one way or the other as it relates to this project. But I will just ask that those, aside from these two handsome gentlemen in suits up here and any of their designated folks who may speak on behalf of their respective clients, is that anybody in the audience sort of hush up in the most respectful way as possible. There is no room for public comment as it relates to what we're dealing with here tonight. And the last thing I want to do, now that I have a real gavel instead of like kitchen, implements, is start whacking on the gavel to hush everybody up. So I ask that, ourselves included, that we respect this process. We respect the work that has gone into it on both sides, from Attorney Winter and Attorney Brodsky and their clients, and that the public listen in, internalize whatever sentiment you may have about what may come out of these guys' mouths tonight, and we'll get through this thing as efficiently as possible. But make sure everybody's comfortable, and I will also, like I did last week, to the extent that I remember, but if there needs to be a pause or a recess so that folks can use the facilities or just get out of this room and stop listening to us talk for a little bit, I totally get it. So that is the one thing when folks can raise their hands, because we're a community, we're all in this together, and we need to take care of each other as we go through this process. So unless I'm missing anything, folks, I'm going to hand the mic to Attorney Winter.
Thank you, Mr. Chairman. And just for the record, Brian Winter, representing the planning board this evening. I am by myself this evening, so I don't have any planning board membership schedules being what they are. I didn't want to delay the proceedings unnecessarily, and so I'm here on their behalf to speak to you. I have a presentation that I'd like to make to you. In that regard, I understand that you have my letter from some time ago, and so I understand that's part of the record. There are just two housekeeping matters that I just wanted to just very, very quickly before we got going, if you don't mind. And one is, I think Attorney Brodsky and the board and I even will refer to the record. I'm not sure, and maybe I just didn't put it in my notes, that we actually clarified what the record consisted of. So we have the materials that were posted on the planning board website. I know the zoning board has a corresponding website, and those were the public hearing materials. So again, I'm not objecting to anything, I'm just looking for a little clarification on that. Does that also include the planning file, the planning department file, or is it just the hearing materials that are on the website for the planning board?
It's a great question. And because, again, this is, I think admittedly, a fairly new process for most, if not all of us, as to how this is to proceed, is that we are kind of, living within the bylaws and the statute that allows us as the zoning board to hear this appeal, plus the various references to case law that either side has sort of informed us to guide the outcome here. So Renee may correct me if I'm wrong, but Brian, to sort of address your question, as far as I know, and for those who are here and those who are on TV, the materials that are tied to our website on the Town of Hull website, there's like two little sections. One is a section that relates to the planning board, and you click on the link and there's just all sorts of stuff. The other click is referencing this specific meeting. I think it was tied to August 11, but it includes a great majority, if not all, of the documents, less maybe what you had submitted, Attorney Brodsky, like today or yesterday or what have you, but the applicant or the petitioner's side of things. So to sort of circle around and get back to what you're thinking, as far as I know, and Renee, you can correct me if I'm wrong, is that everything that was in that planning board link is part of the underlying record itself that led to this decision of May 19, 2026. If there are other things that are out there, I'm not aware of it. Renee, I think, am I speaking out of school here? Is that?
I did speak to the assistant town planner and the town planner, and all the documents that are in the planning board's file for this project are on the website, unless something has inadvertently dropped off with it.
Right.
There are emails that you requested between the town planner and Attorney Brodsky. Those are not on the website, just because it's about 800 pages of, meeting on Tuesday, but they are available if anyone would like to look.
And as sort of a guidepost, and I also, let me correct myself, like in addition to the documents that are linked to our website, I do know that the ones that are specifically tied to this very meeting, in addition to the materials submitted by Attorney Brodsky, there is also, a fair amount of correspondence from the public. Those items are noted, but they're not factored into tonight in any way or form. So what I'm trying to do is just sort of use as a point of reference, trust but verify, is that within this May 19, 2026 site plan decision, there is reference to plans and materials that I guess appear to be sort of, reference points for what was factored into the decision after what I believe to be, and Rebecca, you can correct me if I'm wrong, the May 14 meeting?
Yes.
All right, so these are the dates that I gotta live in. May 14 was the meeting, May 19 decision. So does that answer your question in some roundabout way?
For the clarification, Mr. Chairman. and
Okay.
To your staff as well. And again, I wasn't raising an objection, I just want to understand better. As the board is aware, there may be all kinds of communication and things that happen outside of the board hearing, like concerning the board hearing. But if it wasn't before the board, I just wanted to have a better understanding of what constituted the record. And so, again, not raising an objection. If it was before the board, it's recited in their decision, it's on the website. That's consistent with what my expectation was.
Right, and really what it comes down to for us in our review is, looking at the substantive documents, reconciling those documents with what the planning board may or is obligated to consider pursuant to the applicable bylaw, but that, like, the other things, like the scheduling emails and back and forth correspondence, like that stuff, as far as I know, has nothing to do with the price of cheese here. So I guess with that, the floor is yours.
Just one more question, and again, just a point of clarification. The slide deck that was presented last week, I believe the board determined to treat that just as a chalk and not independent evidence. And I just wanted to confirm that my understanding is correct. The reason I raise it is because the last page of that, and keep in mind, I was handed it at the hearing, so I didn't have a terrific opportunity to review it, but I did review it in the time since. The last page contains sort of excerpts, snippets, if you will, of sort of statements that were allegedly made pursuant to some transcript. And so if it's just a chalk and the board's just gonna take it for what it is, I'll speak more on the subject, but if there's any concern that the board might be relying on the truth of those statements or the merit of those statements, I do wanna put an objection on the record. What individual planning board members may have said or not said at the hearing is not evidence. It's not a transcript I've ever seen before. To my knowledge, no one's agreed upon a transcript. There's minutes, there's a recording. I don't know the source of the transcript, and so I just wanted to put that on the record. I'm not gonna spend a lot of time arguing over it. But certainly if the board is interested in reviewing that record in its entirety, I invite and welcome the board to do so. But perhaps through the official channels and the entirety of that, and not just selectively chosen sentences here and there. And so,
and I agree, and that's exactly how I took it, is that I understand and appreciate Attorney Brodsky's presentation based on, yes, that chalk. I think it's helpful as a demonstrative aid. I think it helps in sort of guiding their position. For us attorneys, it's always nice to have something to look at to make sure you're tracking yourself. But none of it is anything that we are going to consider beyond when we saw it up on the screen. And I would say that it's, in calling balls and strikes, the same would be if you were to have a similar slide deck to put on there. So much of it can be viewed as being sort of subjective or persuasive, and I say that for both ends, right? So all we care about is what got us to that decision, nothing more, nothing less. So certainly, if you have a similar chalk in some way or form, you're more than welcome to tie it into tonight's presentation, but it will be treated equally, and I say this respectfully, but quite superficially, right? It's more of trying for us to because the chronology is great. Like, the chronology is helpful to have, but we know where we are. So that's what I would say as it relates to that.
thank you for that. I appreciate it, and also consistent with my expectation and my understanding of how things were determined last week. Just wanted to clarify that.
And just before I shut up, and as I said, I was going to shut up hours ago or minutes ago, but this is an administrative board hearing. It's not a court of law. Yeah, there are a bunch of attorneys, here tonight, but, typically the rules of evidence and the hearsay and all those different kind of things have no place for this, just because, not every board has, legal counsel on it, and it's a different kettle of fish. We'll factor in everything and deal with it as it comes, but I hope that comforts everybody, or at least puts everybody in a position where we're all on an even playing field. So yeah, go right ahead.
Terrific, and thank you, Mr. Chairman. And my apologies, I should have asked this at the outset, but it's up to the board, of course. Would you like me to take the lectern? I'm happy to speak from here, but if other people can't hear me because they're seeing my back, I'd be more than happy to take the lectern.
Yeah, not that your backside is something disagreeable, but certainly I think from an auditory standpoint, getting up there and vocalizing so that as long as that mic works, right? Okay, so mic works, and yeah, and sometimes you don't feel as sort of exposed behind the dais.
So the mic only works with the television, not the...
All right, so mic works for TV, so just use your lawyer voice. Yeah, or
Well,
big
if there are
boy
any
voice.
issues, please just alert me, and we'll make an adjustment as we go. But I'll begin, and I first of all just want to acknowledge and thank the board for at least offering to give us equal time to make our presentation. It's just me this evening, and so I'll make my presentation, but I don't expect to or intend to present any witnesses or have any members of the planning board. present separately to you. So you'll hear from me. I'll do my best to answer your questions. And I don't want to get ahead of myself right now, but if there are any questions that I'm not able to answer, I may want to have a conversation with the board about how best to handle that.
Sure.
And really, this is just kind of an adjunct to the fact that I'm not representing a private entity or an individual. I'm representing an organizational board. They have open meeting law requirements and other kind of legal requirements upon them, and so it's a bit of a challenge to have the planning board here meeting and representing itself, and so that's why I'm here on my own. So with that caveat, I'll jump right in. So I wanted to begin my presentation with just sort of what I'm going to refer to as sort of the elephant in the room, which is administrative site plan review for by right use. And so Attorney Brodsky's presentation touched upon this. I know the board has counsel. The board may have questions of its own counsel on this, but I just wanted to start with this kind of essential point because it's an unusual situation to ever be reviewing the denial of an administrative site plan decision that's not attached to a special permit when it's a by right use. So I want to just start with a couple comments on that because all of us have referenced this Prudential insurance case v. Westwood. And I'm not going to make this a legal argument as though I were in court, but I just want to touch upon a couple of these points. And there is a very narrow exception when there's a by right use that's subject to site plan review. It's not something that boards see very commonly. It's not something that occurs every day. But that doesn't mean that it is invalid, and it doesn't mean that that process doesn't exist. And so there's the famous or infamous footnote in that case, depending on your perspective on this matter, and it articulates, essentially the guardrails for when a planning board or whatever the site plan review authority might be, when the situation may call for such a decision, a denial. And again, when it's by right, it shouldn't concern the underlying use, but it should concern other things, or could, I should say, concern other things. And those are really fundamental principles to any kind of adjudicatory board reviewing any kind of application. And so the sufficiency of the information, that's fundamental to any application, no matter what it is. The timing of the information and when it's submitted. Is it accurate? Is it complete? Is it sufficient within the four corners of your jurisdiction? And in this case, the planning board's jurisdiction is under the site plan review bylaw. And then lastly, is there sufficient time to review that information? And I don't mean the 105 days that's prescribed by the bylaw. I mean based on the date that it's received and the process necessary to review, to vet, to peer review, to understand, to ask questions, to get answers to those questions. And so the zoning board, the planning board, any land use related board works under a statutory architecture where it has deadlines. But every single one of those deadlines is premised on receiving complete, accurate, and sufficient information to allow the board to do its job. And so that's what the footnote gets to in the Prudential insurance case.
Richard, excuse me, would you like us to hold questions until the end of basically his primary presentation, or can we intervene with questions as we go?
Oh, intervene. That's way more fun.
Okay.
Yeah, I mean, we all intervene, no matter what. And not to, push you off your focus, but I think the same thing that we did with Attorney Brodsky is that as questions came up, we all politely, in our best form, may have interrupted him just to get some clarification. So yes, as it relates to the folks who are here, certainly you can ask questions as it goes.
Okay. Attorney Winter, I do want to spend a moment on Prudential because I think it's so essential to understanding how the planning board should have made its decision. And I want to first clarify that the opportunity, if you will, to deny site plan review is in a footnote. It's not the primary decision of the case, correct?
That's correct, yes.
Right. And what was the primary finding of the case in that particular
So
suit?
I can speak to it if you like, but I understand the board is represented by its own counsel, and so you may end up with 3 opinions on what this case means. But the Westwood case, Prudential, which, by the way, I know it's a footnote, but it's a footnote that's cited 40 or 50 times in other cases. And so it's a footnote that, for lack of a better term, has made the rounds. And so this is why it's often cited by attorneys. And so I'll just, and again, I don't want to interpret it, I'll just read
Right.
it to you if you like, because.
I think what I'm getting at is that there's a tension within that case itself, and a statement, and a batch of statements within that case itself that is also quoted multiple times in later cases, that effectively, well, in fact says, if the specific area and use criteria stated in the bylaw are satisfied, the board did not have discretionary power to deny approval. And so that is within the holding of the case, right? And so at minimum, there's a tension between that statement and
Yes.
and that it goes on to say they are allowed to condition the use but not prohibit it.
Correct, and I think they were,
so
used
we
the
don't
term
have a-
improperly forbid and otherwise by right use,
Right.
yes.
And I'm also interested if you know whether later cases that cite that footnote, this sort of opportunity to deny, if you will, are cases in which site plan denial was upheld or in which site plan denial was overturned.
So, well, let me, if I may, just take them in order a little bit. So, yes, I recognize the tension in the case that you're referring to. That is part of the nature of that case. But I also think it's inherent in site plan review. And so I'm sorry if we're digressing, but one land court judge very famously said site plan review is the ghost in the machine, because it's not a product of the Zoning Act, Chapter 48 of the general laws. It's a product of local bylaws, home rule authority. And so the case law is sort of divorced a little bit from normal zoning case law, because it's not an area and it's not a regulatory architecture that comes from the statute, unlike, variances and special permits and all the other things that do. And so that tension is sort of endemic to the nature of site plan review. So some towns do what we're talking about here, which is administrative site plan review, which is a site plan review tethered to a by right use. There's another kind of site plan review, and it's an important distinction, which is why I'm making it, which is site plan review tethered to a special permit use. And so those cases go in different directions, right? Because if it's tethered to special permit, there's more discretion involved. With respect to now I'm going to get back to, I think, your last question a little bit. So that tension is just sort of inherent in it. For example, a building permit is a product of 780 CMR, the building code. So when can a building permit be denied? Well, it really shouldn't be if it's otherwise compliant. If they've submitted sufficient information, accurate information, and complete information, and it's timely, then the building permit, you would think, would issue. So it's very akin to that, because we're talking about a by right use. So there have been cases, many, many cases that cite this provision. I'm not going to venture a guess, but as I mentioned before, maybe ballpark, 40, 50 plus cases that have cited that footnote in reaching their eventual decision. I'm not aware of any case that ultimately affirmed the denial on its merits. I am aware of cases where the court said, I can't decide, and I'm going to send it back to you to do it again, what we call a remand. And so the court heard the evidence, determined that there was at least sufficient reasons for the board to maybe have been concerned about some of those things, but also sufficient reasons why the applicant maybe could have done a little better, maybe did a lot, but ultimately it resulted in a remand for the board to then take another bite at that apple. So I don't know if you would call that affirming the board's decision or overturning it. It was just remanded. So I have seen cases to that
Remand means
effect.
it's not affirming it.
Right.
It's not enforcing the denial.
But in that same case, the court did not say that there was the grounds cited by the board were so deficient that the permit should issue. And so at the end of my presentation, I will touch upon like remedies, and that we'll have a conversation I expect about that part of it. So I don't necessarily want to jump ahead right now. But a remand isn't saying your decision is so fatally flawed that there's no version of facts that could possibly support it, and therefore I'm vacating it, and I'm ordering you to just grant the approval. So in a few cases, the court said, maybe that's justified, maybe it isn't, I can't tell on this record, go back, hold a new public hearing, and let's see what happens. So
But
that's
there are a
little
number of cases in which there is a repetition of this premise that the site plan approval for a by right use that is
Yes.
not for a special permit is distinct
Yes.
from a special permit site plan review.
Yes.
And has a much narrower needle that it can thread.
And-
that, by and large, the language repeated often is, you may not prohibit, you may regulate by reasonable condition. Is that fair to say?
Oh, it is, and
Okay.
I'll actually, if you don't mind, I'll just sort of cut to the punchline, which is the vast majority of cases cite it and then say, this isn't such a case.
Correct.
And so I think that's what you're driving at, if I might be
It's
mistaken.
not one of the
but-
special footnote
Right, it
exception
is
cases,
because
right.
it's an exception. It's a
Right.
rarity.
So that bar, I think, set by the footnote is maybe a lot higher than one would expect if you just read it in a vacuum.
I don't disagree that it's a high bar because it's meant to be the exception to the general rule. And so it shouldn't be satisfied cavalierly or typically, otherwise it wouldn't be an exception. And so I don't disagree that it's not something that should customarily happen. And in a normal process, site plan review by any board should result in an approval that shapes the project with conditions. That's what site plan is for. And so in my letter, by the way, I do walk through this a little bit. And so, you know, that is the state of the law. That's the circumstance we're in. And so I'm not saying otherwise. But to get back to the point that I was making earlier, the question for the board is whether or not this is such a case, and whether or not the planning board's decision details sufficient reasons. I mean, we'll walk through all this as we go, but the ultimate sort of outcome determinative question for this board is, and I'll just sort of try to put it in sort of a one-sentence summary version of it. If the planning board did not have sufficient information, if it didn't have sufficient time to review that information, then did it have a fair opportunity to perform its duties as elected members of the planning board to approve a project when it wasn't in a position to make the findings necessary to do so? And so that's where the rubber meets the road, so to speak, with this. And so you could argue, as the applicant has in this case, we submitted lots of information, extensive information, revised information. We submitted again. We submitted comment letters. But the question is, did the planning board have an opportunity to get the clarification it needed, to have it peer reviewed? Was it submitted at a time, and was it submitted timely so that the board could do those things? And were the things that the bylaw requires the things that the planning board got? And so I don't mean to put it in any kind of curt way, but supplying information is completely different than supplying complete and accurate and responsive information, and it's completely different than supplying it in a timely manner. And so I'll explain what I mean by that as I go along a little bit, but I think that's the ultimate question. And so I want to walk through just a couple categories or subject matters, sort of topics broadly. And so I just want to sort of revisit, you know, what the actual requirement is for the planning board in issuing its decision first. And so some questions came up on the first night about, well, what is required of the written decision in the first place? And Attorney Brodsky spoke to that point, and the board had a number of questions on it. And so I just want to bring it back to the tether to the zoning bylaw. Right? And so this is 410-4.1 C5A. The planning board may grant approval, may deny approval, or may grant approval with special conditions based on its review of the projected development impacts and the proposed method of mitigating such impacts, and whether the proposed development is in conformance with subsection D, design guidelines. That's all the bylaw says. And so how do we extrapolate what's required from that, because it doesn't say shall prepare detailed findings, determinations, conclusions, and so on and so forth. But we all know that that's customary for boards to do, right? And so, of course, they need to do that. And so we have case law that teases that out a little bit more. And the point I want to make with you on this specific topic is there's a big difference between granting and denying something. And there's extensive case law on this. And so Attorney Brodsky's point, which is correct with respect to a grant, is any board has to make detailed findings, conclusions. It needs to be tethered to the record. It needs to be explicit. It needs to give the public, the community, and everybody else an understanding of how the board used the facts that it found to conclude that all of the specific requirements of the zoning bylaw were met. So that's with respect to a grant. So this is just sort of basic, common practice. But unlike a grant, when it's the case of a denial, there's a much lesser standard. And I'm not saying it's zero. I'm just saying the standard is less. And there are a number of cases on this point. And if you'd like, just very quickly, the McGibbon case, that's 369 Massachusetts 512, 1976. It's one that's cited very often for this proposition. Davis v. Chatham, also cited for this proposition, a more recent case, that's 52 Mass Appeals Court, 349, and that's 2001. And the takeaway from that is that when there's a denial, it doesn't require detailed findings in order to be affirmed by the reviewing court. I know we're not in court.
Could you clarify when, in that case that you're referring to, a denial of what?
Well, just one, let's pause real fast. So for those who didn't make the regrettable choice to go to law school, let me just tell you this, is that there's a lot of discussion going on right now that refers to legal precedent that sort of frames why we're here. The case law that has been referenced by Attorney Brodsky and now Attorney Winter, these things, because Attorney Brodsky also brought up, if we're really sticking to what's been submitted and what our charge is, certain cases were referenced in everybody's sort of position paper, but Attorney Brodsky and now Attorney Winter are also now referencing, based on questions, some additional, either subsequent, more recent case law, things that could clarify some issues of confusion. I don't see a problem with going down this rabbit hole to the extent that it may bore people to tears hearing about case law tonight. But I think it's helpful because just so that everybody knows, the thing that sort of guides tonight and any subsequent night as it relates to this project, what guided the planning board are this chapter 410-4.1 site plan review. That's sort of the gospel. Those are the bylaws that are, for good or for bad, those are the bylaws that are in play. So to the extent that reference, as Attorney Brodsky did last week, to some cases that may have, spun off of the Prudential case, and now Attorney Winter doing the same sort of thing to respond to a question from the board, I think is instructive and helpful to us, and in a weird, perverse way could be kind of appealing to those uninitiated in the audience to learn. So I'm cool with that and proceed. Sorry for interrupting.
And this is the last point I want to make on kind of the legal points, and so I do want to respond to your question and discuss it a little bit more, but I am going to move away from it on the next point and get into the decision and the record a little bit more. So a number of these are special permit cases, the McGibbon case, the Davis v. Chatham case. The next one I wanted to cite is the Cephalo case. I believe it's also a special permit case. But that sort of general posture is consistent on approvals and denials across all zoning cases. So the same standard has been applied to variances. The same standard has been applied to any written decision of an adjudicatory board, whether it's variance, site plan, all the different things boards do. There's just a lesser quantum needed in the written decision. And the Cephalo case, and I can give you the citation, I can provide it later if you want. Again, I don't want to get too deep in the weeds here on the legal issues. I'm sure you'll speak with your own counsel about these things when you get into deliberations. But the quote there in that case is, "It would be a matter of considerable difficulty, especially for laymen, to state in detail all possible factors, the non-existence of which resulted in the denial of the application." And so the problem is sort of proving a negative, right? If you have to identify every possible reason that went into denial, that's not a very pragmatic approach to writing a denial.
Was that case a special permit case?
I believe that was a special permit
Okay,
case.
so a case in which there was far more discretion than there would be afforded a site plan review of a by right use.
Certainly so. A special permit
Okay.
would be such a permit. But I'm not saying that that level of detail is any different in any other kind of zoning decision that's written. You'll see the same cases recited under variance decisions and all kinds of other zoning permits. It's the paradigm that I'm trying to highlight in this case. Not that it was applied in any particular circumstances. It's applied broadly in review of denials, that same sort of approach to it. And again, the rationale, which I just cited, is the same reason it's cited each time. Because there may be, I don't want to say infinite, but there could be a long list of factors that a board would then have to list as being non-existent in order to make its case. And so it's just a different standard for a denial. So at any rate, I don't mean to belabor the point. And so in this case, and this is what I want to get into next, is the requirements of the zoning bylaw and the actual decision that the planning board rendered. Because here you don't have nothing. You obviously have a written decision that was arrived at after a robust public hearing, and the decision, particularly on the last 2 pages, contains detailed findings, and it contains a determination and a conclusion, and then the unanimous vote of the planning board. And so you do have a statement of
One quick
reasons.
pause. So when you reference robust public hearing, that is sort of, that references not just the meeting that occurred on May 14th, but all the preceding meetings leading up to that. So
Yes.
it's like, when we reference hearings, right, we're here tonight, we were also here last Tuesday. It's the same hearing, just 2 different dates. So it's not, when he's referencing hearing, it's a global reference to all of the hearings that came to, ahead on May the 14th. Am I getting that right?
Entirely correct, and I'll state it my way. I refer to the public hearing as collective. They're individual nights, but the entirety comprises one public hearing. It's opened, eventually, it may be one night, it may be 20 nights, it'll close. That's one public hearing. So yes, that's accurate. So the zoning bylaw has a number of requirements for site plan. Just by my own sort of hand count, 11 categories for materials to be submitted, even more categories if you break it down into the subcategories. That's 410, 4.1 C2, A through C, and then 3 A through H. So those are just submission requirements. And there's 11, depending on how you count it, or even 20 if you count it that way with the subcategories. And then there are 20 design guidelines in 4.1 D1 A through H, and then 2 A through L. So there are extensive guardrails and requirements both for the planning board to adhere to and for the applicant to adhere to. So
This could be helpful too, just because, attorneys live in the land of may or shall and all those kind of things. May, a little bit more forgiving. Shall is you must. And Attorney Winter, when you were breaking down these bylaw, like this, if we land on 410-4.1C, there's one basic requirements. That has an application for site plan review shall be submitted, okay? And then you have 2 materials required. An application for site plan review shall be accompanied by, so shall means you must. Doesn't seem very discretionary. And then when you get on to subsection 3, additional materials required. Required is sort of an interpretive word, because it states after initially reviewing the proposed site plan, the planning board may require that the applicant submit any of the following materials that go, A through whatever it may be. So I think it's important both for everybody to recognize that there's sort of a difference, like from a discretionary versus like there's no room for movement, right? Yeah, okay.
Yes, understood. And so there are a number of points I want to make just on the decision itself and the grounds for the planning board's ultimate determination. And we've heard arguments from the applicant just about the volume of materials that were submitted, and I was here and I heard, you know, a lot of the discourse about confusion about whether it was sufficient. Applicant certainly is stating to the board it was. Planning board's decision argues otherwise. And so there's a whole process, and you've seen it in the record that you have, reflected in the minutes. If any of the members care to listen to the recordings of the board meetings, you would have heard the same discussions going back and forth, and I'll let that record speak for itself. I'm not going to go through, you know, every sort of he said, she said moment in that. But there are a couple highlights I want to hit, and a point that I want to make, which is on the last planning board night, when it concluded the hearing on the 14th, one issue came up, and that was, you know, why hasn't anyone requested a waiver, or can the board grant a waiver of any of these things? And so one of the ways that we resolve the tension between, well, what did you submit and what did we want, and is what we want actually something necessary for this, or is it just something recited in the bylaw, is to have a conversation about waivers. I don't see, and I don't see reflected on the planning board's website, that any waivers were requested or discussed. It didn't appear upon my review that waivers were even brought up as a possibility until the last evening.
Attorney Winter, can you be specific about what you think a waiver would have been about? I feel like it's getting a little fuzzy. You know, I'm not sure speaking to a volume of submissions is necessarily the same as saying those submissions did or did not meet the shall/may requirements. Can you break down for me what the planning board is saying was not submitted?
So,
and
yes.
and whether it was a shall or a may. And
then let me piggyback on that, Attorney Winter, is that I'm, you know, the concept of waiver, again, for those watching here and on TV, that can be a bizarre concept too, but I think, and correct me if I'm wrong, Attorney Winter, is that the board actions under 410-4.15, you know, it includes this language that the planning board may, again, focus on that term, also waive the requirements for site plan review if, in the opinion of a 2/3 majority of the planning board, the adverse impacts of the proposed development are not significantly greater than the impacts of uses which are or can be made of the site under existing laws and regulations. Is that kind of like where you're talking about?
Well, I think I'm not yet at the question of waiver, because I'm not entirely sure what the planning board was identifying as the shalls that were not met, not just volume-wise, but responsiveness-wise, and what the mays were not met, so that we can kind of really home in on the question of sufficiency of information or insufficiency of information.
No, understood, and let me make it more concrete. And I'll tether it to the planning board's decision, because that's what's under review, right? And so depending on how you look at it, there were 6 findings, you know, beginning on page 3 and ending on page 4 of the planning board's decision. So what I'll call subsidiary findings.
We'll pull up the decision.
Yep, certainly.
keep going, I think it'll come up.
Okay. Well, I don't want to get ahead of anybody and.
You need the Jeopardy song. Look at that. Look at that. Wonders never cease.
Next one, please. There.
Got it. Everybody get your glasses out.
I'm standing right here and I can't read it. Yeah, is it?
No, thank you.
I think we're up.
Should I continue?
Yes.
Okay,
thank you.
terrific. I did want to provide a little context, but I'll circle back to it because I want to answer your question. So to use concrete examples, I want to just use the actual ones in the decision. This is what you're reviewing. So the first, I'll call it a subsidiary finding under the findings section, but it's not their ultimate finding. That's on the next page. That's their decision, ultimate conclusion. So the first one is a failure to provide sufficient information and timely information, essentially, and I'm paraphrasing. Failure to adequately describe the project such that the board cannot make a determination on the merits. So that's a bit ambiguous. It doesn't really tell you anything concrete.
I'm sorry, that's a what?
That doesn't have the specifics in it that you're looking for. That's a general statement of sort of their dissatisfaction. The next one, if you go down, refers to the model. And there was a lot of discussion about this model, and this is one of the reasons why I brought the waiver issue up. Because an easy way to address the sort of differences of opinions with respect to this model would be to look at what the bylaw requires, what was submitted, and request a waiver of things that the applicant didn't think was valuable to produce for the board. And the board could then have an opportunity to say, you might be right about that. We don't need a physical model. The bylaw doesn't say physical model, right? It says a model. At the same scale as the site plan showing the entire project and its relation to existing areas, buildings, structures, and roads for a distance of 100 feet from the project boundaries. Now, what kind of model? What's sufficient to satisfy the model requirement? Maybe there's some interpretation in there, and the planning board has the power to interpret that. But what they need to have is something in front of them to give them the opportunity to make a ruling on it. They didn't have that. A request for a waiver, that's
So,
traditionally the thing.
Yeah, I'm not talking about a waiver. I'm trying to identify when there is a paragraph that says the project is insufficiently described. What I heard you say just now is that that's a general statement, and then you would get into the specifics. Are you saying that the only specific that the planning board identified as not being sufficiently presented to them or waived is the model? Is that the only
No,
lack
that's
of
the
it? So
first
where
one.
was the other, what
That's the
other
first one
information?
that I've
And
mentioned.
allowing me to sort of steer traffic, Ms. Rogers did reference waiver, so we're dealing with like two different concepts right now, but I think, the waiver discussion analysis, I think, can be addressed and explained by Attorney Winter to the extent he wants to after we get into the nitty gritty. Because, right, like, as far as I can see, the one specific reference point to these additional materials required where there's a may attached to it. The one thing that appears to be missing underneath this category is that model.
Cardboard model.
Yeah, right. So, right. And I think if everybody recalls from last week, there was a robust discussion from, I think, Mr. Fleck or Attorney Brodsky that like, listen, gone are the days where people are, gluing together cardboard and putting these things kind of together. So there's some, obviously, interpretation based on what this bylaw, for good or for bad, requires, right? So I hope I'm not stepping on your toes, but I think just to try to, narrow.
That's very helpful,
Okay,
yeah.
cool.
And I think what I'm getting at is, if you're trying to thread a pretty narrow needle, and you're saying there's inadequate information under the prudential standard, and I get that there's nuanced feelings and impressions and parts of a discretionary review that are really hard to quantify in explaining a denial. But it seems to me that stating what is not there and that makes the project insufficiently described is an essential part of a decision. And what I'm construing from the decision, and just the contents of the decision, is that the only thing missing was a paper model. Not a model in general, but a paper model. Is that correct?
Respectfully, no. That's the first one I mentioned, but I will disagree just because there are several instances that the board cites specific deficiencies in their opinion on that page 4. The model is the first one that I just used because it's the first one that follows on that page. The second one is unresolved concerns over traffic, and there was a discussion last week about the expert nature of the traffic study and things like that. But the second point the board makes after the reference to the model is concerns over traffic. Traffic remained unresolved. The board had concerns about how could they make a decision when that is still an outstanding item.
Got it. And again, just to keep everybody on the same track, and my apologies if this was covered, and I also apologize for inserting myself into this, but that, the reference to the model, that's the one item that falls within the application and review procedure under 410-4.1C. The subsequent reference to this traffic issue, that goes with the design guidelines that has a may attached to it, which is 410-4.1D. So just so that people can track to the extent that they're, relishing holding this regulation before them.
Thank you.
Got it.
And even the I don't mean to interrupt,
Keep
but I
going.
just
Keep going.
one very quick point. And even the model, I don't think it was even argued at the last week's hearing of this board that it met the 100-foot requirement that's recited in the bylaw itself. So now we have the planning board citing a specific concrete example of how it believed the applicant did not satisfy the requirement of the bylaw and also did not request a waiver of that. And I don't want to get back to the waiver right now, but
So
that's a concrete example.
I
One.
think that's not what the decision says. I think what they're saying is there is an insufficiently described project. It's inadequate information. And what I construe from that first paragraph leading into the models, before we get to traffic, is that the model is the only thing that would have helped the planning board understand the project, that without it, the entire project is insufficiently described.
Respectfully, I don't read the decision that way.
Okay,
And
so
here's
how
just-
is else
wait a
is it?
minute for 1 second here, is that as much as, and I think it would be inappropriate for any of us on this board, voting, not voting, to inject our own sort of interpretation of what this decision says. And absent counsel telling me something different, I think we have to be like literalists, like the sentences, the words, they are what they are. And I don't think any of us on this board can step into the mind of the planning board folks, aside from what is in this decision. Is counsel, am I kind of like, I'm not trying to put a
And
pin in your balloon.
I'm not trying to enter into their mindset. I'm asking what they meant. And if that's an impermissible question, I think it goes to the question of how does one insufficiently describe, like how did the project end up being insufficiently described? Was it only the model? if it was more than the model, what other pieces of information were missing that led them to the conclusion that there was inadequate information.
I
Not
understand
just
your-
that we asked for it and you didn't give it. I think it really goes to the question of, is information adequate?
Of course. And again, I'm not trying to get into their minds at all. I'm just working literally off the words on this page. And so right under that sort of prefatory statement, if you will, about failure to provide sufficient information, right under that, the sentence says, to the extent the board has been able to consider the incomplete information provided, the board also finds as follows. And then the paragraph right after that refers to the model requested. And so that's why I presented it in that order. So that's the first example the board gave, not me, not interpreting the board, but literally on this page, said there's insufficient information. For example, number one, the model requested was not supplied.
Got it, and I think that
And then
would
it
be.
continues.
Yeah, and what would be helpful too is, if I recall correctly from Attorney Brodsky's presentation from last week, there was this discussion about the decision itself not having, for lack of a better term, sort of like notations or parenthetical items that, or a footnote. So when these findings, as they are sort of put together on this page, certainly make reference to the applicable bylaws that support the inclusion in that decision. But one thing that I thought was compelling by Attorney Brodsky is like, well, great. Like, I guess, and we're going to get into this about the traffic, but it was like, you're just making a decision as a layperson on the planning board that what has been submitted doesn't meet the threshold for what the planning board may or shall consider and interpret. But it may be helpful, Attorney Winter, to the extent you know, and it's a lot to sort of put you on the spot, but in the plans and materials section that precedes these findings, there's all sorts of things that are identified here that at least I believe to have been sort of factored in to the outcome. And I'm wondering, just to sort of, make this, the record of these proceedings sort of track with what is in the record, is that when the board writes that to the extent the board has been able to consider the incomplete information provided, the board also finds as follows, as it relates to this, the model issue. So I have to imagine, and this is me sort of going against my better judgment here, but that the planning board, when pen was put to paper on this, is that they assessed what they had as it relates to this particular additional materials required, and made a determination that the applicant refused to supply a requested model as identified in this section. So getting to the point here, I'm wondering is, for the people that don't understand the various entities or individuals that created the plans and materials that are part of this record, is there anything in particular? Like, I know that the petitioner made reference, and I think it was part of the chalk as well, as to these, like, three-dimensional drawings that were submitted. Do you happen to know what drawings those refer to as it relates to this list of plans and materials?
Yes, so I believe that is a reference to renderings that were submitted in the plan sets that were revised from time to time over the course of the public hearing. So I can't tell you the exact exhibit. I apologize for that. But the most recent plan set that I believe was April 29th has pages in it, sheets in it, that include, I'm just going to hold it up so you see the reference, but these are very similar to the graphics you saw the previous evening last week.
So that reference point, so I see, like, there are two, so Monty French, if I'm pronouncing that right, I imagine that's the design firm that put together these drawings. So this reference to 839-843-845 Nantasket architectural plans with like a point of origin of January 12, 2026, and then 4 subsequent revisions that bring us to April 29, 2026, you know, a couple of weeks before the May 14 hearing. But then there's also reference to renderings, also by Monty French, dated April 15, 2026. So is it a combination of those two, one or the other, to the extent that you know?
So my understanding is that the reference to models and renderings refers to the Monty French Design Studio sheets within that package.
Okay.
And I believe when Attorney Brodsky was making his presentation in the chalk, the slide deck that he provided to the board, he was referencing a similar set of 3D computer modeled renderings.
Okay.
Again, I'm not trying to put words in his mouth. He can speak for himself, of course, but that's my understanding of what that reference is to. And this is now, to bring it back to the planning board's decision, they're citing an insufficiency, a lack of information. And I'm just using this one example, not the only thing that they cited, but this is the one that we're on right now. And they're saying that this is insufficient because it doesn't provide the information the bylaw requires. There isn't a 100-foot sight distance. And so even looking at the renderings you have right in front of you, and even the ones in the slide deck, there isn't a 100-foot sight distance to those. And so this is the board reciting in its written decision, making a finding that that portion of the zoning bylaw, that provision, in their opinion, was not satisfied, and therefore that is an example, not the only example, but an example of how we didn't receive sufficient information to understand the project. And so that's the first one. There are several others in the written decision of the planning board. The next one is the unresolved concerns over traffic. I imagine the board has some questions on that. I'm happy to
Yeah, let's
skip
get
to
there.
that one or stop.
We'll get there in just a moment, but if we're, like, I always like these sort of choose your own adventure bylaw setups, right? Because it sort of sets the table where you have the application and review procedure, and then you have the design guidelines, and then you have how we get the decision, all that kind of stuff. So just so it's clear, the board's decision that references this lack of a model at the same scale as the site plan with, you know, the distances of 100 foot from the project boundaries, you know, again, and I'm sorry to just sort of, you know, hammer at this point, we're in this area of the bylaw where it says additional materials required after initially reviewing the proposed site plan, the planning board may require that the applicant submit any of the following materials. So I'm wondering, Attorney Winter, like, and forgive me for not committing all of the record to memory, but in order to get to this finding that C3F was not satisfied, I imagine there had been a request or some sort of back and forth exchange between the planning board and the applicant regarding this very issue. Is that accurate?
I would have the same expectation.
Got it, okay.
As
So
the board knows,
expectations
I was
kind of,
not- oh, sorry.
expectation's kind of a weird word too, because that implies that somebody understands what they're doing. Obviously, the applicant, sophisticated entities, they know their way around, you know, a construction site and bylaws and stuff of that nature. But I just, you know, as it relates to our ultimate decision on this, like, if it's as simple as, you know, once we saw the application, the planning board, we took it upon ourselves to identify, you know, either all of these additional materials required or a select few. But I'm wondering, is if we're living within this section 3 additional materials required, this subsection F as it relates to the model, is that the only sort of, you know, confirmed item that there is this dispute over? And if not, were there others as it relates to any number of these different things, you know, impact studies, conceptual drawings, you know, et cetera?
So there are 3 others recited in the board's decision. In my letter to the board on July 21st, cited additional ones to elaborate on some of the issues.
But that
the
aren't
board-
part of this
They're
decision.
not part of the decision. That's why
Okay,
I
so
said
not
it's
part
part
of
of
the
my
decision.
letter.
So
Yes, I
in
said
their
that.
decision, the planning board did not call out anything else. It was only after the fact when, on reflection, they felt like they needed to produce more items, they did. Is
I
that?
think that's an interpretation that I didn't state.
Okay, so.
I highlighted the fact that they're 2
That
separate
list was made
documents.
after the fact, after the
As I
fact of
said.
their decision.
As I said, it's part of my letter,
Uh-huh.
and I said the date of the letter, and it's part of my letter. I'm just drawing the board's attention to the fact that there is also an attachment to my letter. I prefer to stick to the board's decision. As I mentioned, there are 3 additional points, and I'd like to speak to them. So back to the board's decision. The model is the first one. The second one was the traffic concerns. And if the board wishes, we can circle back to these, but let me just get through the other 2. Traffic concerns unresolved. Owners unknown. There was a lengthy discussion last week about what the requirement is and whether or not that was true at the time the board made it. Attorney Brodsky responded to that. The board has a different view on that subject, and when it's appropriate to do so, I'd like to address that. And then the last one is the peer review, a refusal to cooperate with peer review. So each one of those are,
I'm sorry, say that last sentence again, I didn't hear you.
the last one, and I'm at the bottom of the page, yes, here. So lastly, the board also notes that the applicant refused to supply the funding necessary for peer review, which the board reasonably requested, and there's a citation to the bylaw. So those are 4 reasons in addition to the prefatory statement with respect to the board's belief that there was insufficient information. So now there's 4 articulated reasons in the decision.
All right, so model.
So, right, but I think, like, we sort of did open this can of tuna fish up on like, these other issues, and just because we have to be fair to both sides submitted sort of position papers with all sorts of different things. You know, a lot of it, you know, we can either, you know, focus on anecdotally or really drill down in what the record is. But your letter of July 21, Attorney Winter, does include the point site plan review unresolved items, of which there are 20 different things that are identified, that I believe also, you know, item number 10 is the 3-dimensional model or virtual model not provided. I guess the question would be, and I don't know the answer to this question, but if there were 20 items that are deemed to be unresolved, that, you know, I trust but verify that these are a part of the record that went into the decision, is there any particular reason? And again, we are guided by, you know, section 5, which basically says what the board can do, you know, approve, deny, or what have you, or waive. Is there any reason why the board decided to either just focus on this one issue being the model rather than like a cumulative, you know, for lack of a better term, you know, non-cooperation basis for issuing a decision adverse to the applicant of all these other things?
And
So-
I don't know, are you saying that you believe all of these to be in the record,
Are you looking at the same thing that I'm looking
the
at?
list of
Yeah.
21 items?
Yeah, so.
I don't know, I don't have any knowledge of whether or not they are or are not reflected in the planning board's considerations.
And that's why we're here, which is the fun part, you know. Really, I guess, to the extent that it's helpful to the cause, we can either you know, sort of sugar down the argument is that the board can, pursuant to the bylaws, the board can approve, deny, or what have you. There's no real guidance, at least according to this subsection 5, as to what the decision looks like, right? but that these 20 items, of which, you know, one was, you know, specifically identified, the other 19 could have been added to the decision, correct?
In theory, yes. There is an explanation for that. It's a
Go right ahead.
pragmatic one more
Yes.
than a legal one.
Sure.
And again, I would just invite board to listen to or review the minutes of the May 14th hearing, because the answer is there. So the board didn't, and again, I didn't attend any of these meetings, so I'm at a bit of a disadvantage here, or maybe an advantage, because I'd be listening to the same thing that you may listen to, which is the recording. And so I don't have any sort of you know, predetermined knowledge of what occurred there, because I wasn't there. I listened to it the same way anyone else might. And so what I heard in that recording is that the board for the first time was faced with a request for a continuance that was inconsistent with the request that their staff had made. They had a decision to make, whether or not to grant that request or take some other action. And so for an hour and 25 minutes, they debated that question and several other questions related to it. They ultimately decided to take a vote. That left them in a difficult position, because they had a draft set of boilerplate approval conditions that their staff had prepared, that the board had never discussed publicly or reviewed publicly, and for all I know, didn't even have until that moment. And they had a draft denial. Now, the reason why that is really a difficult position for the board to be in is because if they didn't grant the continuance, then they had to render a decision by the 19th, or the project would have been constructively approved. So they had the draft decision from staff, they had an intervening holiday and a weekend, and they finalized the decision and they filed it. Now, given an infinite amount of time, or even more ample time, maybe the decision would read differently. And so I told you at the beginning, I'm only going to offer sort of a pragmatic answer. You know, could they have written a decision that's different than this one? Of course they could have. You know, but that's not what you have in front of you, and it's not what I have in front of me. This is the decision that they landed on under the circumstances when they decided not to grant the requested continuance from the applicant and to conclude the public hearing that evening.
Got it. And the question, I think it's helpful for you know, the audience to, because I know that was raised because it sort of can create like an inflammatory environment, right? Is that the board, is that I know that Attorney Brodsky had issued correspondence on behalf of the applicant, you know, on May 14th, so before that hearing, where there was, you know, either an overture or an offer to continue it to like the 27th or what have you. I also know, based on what Attorney Brodsky represented last week, is that nobody from the applicant's side was there, and if I remember correctly, Attorney Brodsky, you were watching it from the confines of your home. So what I think that is a weird set of circumstances, because like in a court of law, it's kind of different, is that, you know, a judge can do kind of whatever they want when faced with, you know, either a request for a continuance or what have you. But in this case, Attorney Winter, what I think would be helpful, to the extent there is an explanation for it, but generally, so a request for a continuance that comes before a board, in this case the planning board, is it a discretionary option for the planning board to, you know, either green light a continuance or reject the continuance? So in that sort of environment, when there is this option of a continuance before the board, but the board takes a unilateral position to reject or deny that motion to continue without the actual party that made the offer present, I'm just trying to think to figure out, to the extent that you know, if that is permissible as it relates to the planning board, that they can vote on a motion to continue one way or the other, regardless of the circumstance.
So I can answer that question because I actually wrote to the board and answered that question when they asked me, the planning board, that is. And so I'm happy to sort of recite it from memory right now, because my answer will not have changed since then. And it essentially is that, it's a customary professional courtesy to grant a continuance when requested, when there's otherwise no prejudice to the parties. If the applicant's requesting, and it would benefit the merits that are under consideration by the board, it is a common practice and a customary professional courtesy to grant that. It is not, however, a legal requirement. And so if you are within the time frame to act, and the board chooses to determine that additional time would be fruitless or futile, the board does not have to grant that request. And if you look at the date of that request, it's the same date as the hearing.
Understood.
And so there's no reason to believe that the chair or any other board members were made aware of it, other than the staff, which it recites in the letter. But that happened, over the period of hours from that afternoon to that evening. And so the board was within its legal rights, in my opinion, to not grant that. But again, and at some point my communication is going to be a public record if it isn't already out already. So I'm not saying anything I haven't already said in writing, which is it's a courtesy that is 99% of the time extended to an applicant.
But there's no sort of legal regulatory requirement that upon receipt of a motion to continue, or not a motion, but a request to continue, that there needs to be some, pre-established procedure to address that. And
assuming you're still within your statutory time frame.
And that's, I wanted to
Making a constructive
dovetail,
grant.
I wanted to dovetail on that as well,
Can I
because
just make one clarifying?
in one moment.
Okay.
Is that you made reference to the timing, like the 410 the bylaws lay out like a instruction manual on when things need to happen. And I think you had referenced moments ago that the point of no return was May 19, 2026. The thing that I need to reconcile, and I think the board needs to reconcile too, is this very letter from Attorney Brodsky, May 14, 2026. I don't know when it was emailed or what have you. I believe it's Exhibit 16 from Attorney Brodsky's package. I got an exhibit number wrong last week, so who knows if that is the case now. But there appears to be, a request or an offer to continue the public hearing for May 14, 2026 to May 27, 2026. That, of course, takes us beyond May 19. And then further down in that second, one sentence paragraph there, it says, however, the LLC is willing to assent to the extension of the decision period through June 4, 2026. So it appears that everybody was playing nice in the sandbox in terms of recognizing the complexity of this project, and that by agreement of both sides, you could, effectively waive or park these, rigid deadlines that are in the bylaws. So I'm gonna just figure out can you sort of extend what you were talking about in terms of the discretionary role of the board in determining how they want to go about it, with, even though it's the day of, the hour of, I get it, we're all volunteers, we have jobs, we have things to do, kids to take care of, you can't be checking your email every 4 seconds, but that nonetheless, we have a letter which is part of our record that shows the applicant expressing a willingness to sort of, push the backstop out a little further. And then to the extent that I cut you off, you can certainly.
That's helpful. I guess I wanted to clarify, because it was in Attorney Brodsky's letter what he sent yesterday, the question about, was there actually a vote on the continuance? And I believe from listening to the tape that there wasn't an affirmative vote either way, that there was a vote on the application, but there was not a vote prior to that on the question of continuance. So
can I
I don't
answer that
really know
question
how that
first?
sits
Yeah.
procedurally.
And,
you
and the
know.
caveat here is that as the chair of the board, I've already sort of made a determination that what was submitted by Attorney Brodsky ahead of tonight's meeting is, for the most part, like it's a summation of what went on last week, but there's new nuggets in here and things that may be outside of the record. Anecdotally, you will recognize what his correspondence says, but it's more for context. So with that, and that issue as to like a vote, whether or not you have to have a vote or what have you, you're the best person to be able to explain what went on and how it went on. So
And
go ahead.
I'll do my best to answer that question as I am here tonight on behalf of the planning board. And so, to answer your discrete question, there never needs to be a vote to reject it. There needs to be a vote to grant it, because if they grant it, then that notice has to be filed with the town clerk with the approval of the planning board, and that's notice to the world, because that changes the not statutory, but in this case, bylaw deadlines to act, which avoids a constructive grant. So had the board chosen to grant it, that absolutely should have been a vote, and I would expect it would have been a vote, and they would have done that. But what they did actually, is then move to a vote on the actual merits of the case, which, it's not a vote to reject the continuance explicitly, but if you then proceed after deliberations and discussions with the members to call for a vote, and the will of the board is to call for a vote on the entirety of the merits of the case and decide it, that's tantamount to a rejection. And that's exactly what happened.
Okay.
There was no continuance. And so, could they have broken it into sort of sequential votes for the sake of the record? Yeah, they could have, but it's not a legal requirement.
Just
And so,
wanting
yes,
to know how that's
I'm happy to try to tease
procedurally.
that out a little bit.
All right.
And so I listened to the recording, again, I wasn't there. And so my understanding of how that played out was the board was faced with this choice now. Because they had been going through a hearing process and receiving information and revisions, and now they were faced with a decision as to whether or not this is going to be our last night hearing this case, or whether or not the next meeting in 2 weeks is going to be our last night hearing the case. And this is all discussed extensively in, an hour and 25 minutes in that recording. The board members made a decision, relying on advice that they had received, and decided, would it be worth it to do that? In terms of, would it be productive in terms of the use of our time? Are we going to receive more materials? Are we going to get answers to our questions? Are our peer reviewers going to be able to give us closeout letters during that time? Have we been able to send the 5 or 6 new pieces of material that we got on April 29th to our peer reviewers and to the people that we need to hear from? And is that going to be a sufficient amount of time for us to wrap that all up and then in 2 weeks make a decision on the merits? And so that's where the disagreement was. And that's recited in Attorney Brodsky's letter. He says, and this is the third line down, we had further conversations with Mr. Delorio, Director of Community and Development. So not the chair, but the chair's representative, obviously, an agent of the board. And Mr. Delorio requested, on behalf of the planning board, that the LLC agree to 2 additional meetings and an additional extension of the decision period. Now, yes, the applicant agreed to a continuance, but also, yes, the applicant rejected that request. And that's important, because in the planning board's opinion, more time was necessary to receive this information and do the job that they believed they had to do with respect to it. And so, if you go back to the decision itself, and you look at the recitation of the materials that were submitted, and there's a reason I'm mentioning this here and now, because I think it ties in to this point. The board received, after the April 22nd meeting, but before that May 14th meeting, leading up to it, the board received a revised transportation memo. I'm sorry, are you there? No, I'll wait. I think it's one, the decision. Right. And so, you can begin on, oh, when you get it up, it's page 1 of the decision, and then it continues on to page 2. So at the bottom, if you have it in front of you or if you can see it on the screen. So this is what the planning board was getting before its May 14th meeting. So it hadn't had a chance to discuss it as a board, to receive it as a board, to determine how it felt about it as a board. That could only occur on May 14th. And so on May 14th, they got a revised transportation memo, a list of changes and revisions, a response to peer review comments, a revised stormwater report, revised site plans, revised architectural plans, and revised site lighting plans.
And
So
were
this
these,
gets back-
so these revisions, Attorney Winter, were these revisions submitted without prompting, meaning there wasn't a specific, like when you look at just the first one, so site development plans, again, the first date is January 12, 2026, and then there are 4 subsequent revised development plans going from February 18, 2026 to April 29, 2026. These revisions to original documents submitted as part of the application, was that at the request of the planning board, or is that the applicant submitting updated things as things changed, or as the project plans were modified?
I don't believe I'm in a position to answer that question respectfully, because it could be the product of peer review comments. It could be the product of comments from the planning board. It could be the product of conversations on the development team. And the record speaks for itself on that. I wasn't there. I don't have that information. If this zoning board wants it, I can get an answer to that question. But for today's purposes and tonight's purposes, it could have been any of those things. And so usually what happens in conjunction with submissions is there's tracking, right? So from the very first submission to the very last submission, we have peer review, we have tracking, so we know what the changes are, we know why they were made, and in response to what comment or what request. And so that tracks all the way through the public hearing. And so there should be accompanying narratives with every one of these, going to the planning board, going to the peer reviewer that's designated for that particular subject matter. And so all that ultimately leads to something that didn't happen in this case, but the planning board was desirous of it happening, and that's understanding what materials we got, why the changes were made, what changes were made, whether or not they address the concerns raised by the members and the peer reviewers, and that results in what I refer to as a closeout letter. So the peer reviewer, let's say the initial peer review had 25 topics. Here are 25 things, and I'm just making things up right now. I'm not saying that happened in this case, but just by way of example, let's say the peer reviewers identified 25 issues worthy of discussion. And as the plans get revised and the discussion continues, 25, 10, 5, eventually you want to get to 0, or if there's some that just can't be resolved, then that final letter is going to say, I've gone as far as I can go with my counterpart professional, and now it's on you, members of the board. You'll have to make a decision as to which way this goes. But that's what concludes the whole process. And so that's what ideally would have happened, but did not happen because the hearing came to an abrupt close on the 14th.
And just by way of respecting this process and Attorney Brodsky and his squad, you know, again, we are tied to what actually happened versus the hypotheticals. And I understand the convenience of what you're trying to accomplish here, but I guess the better thing would be to do is, like, if the record supports it, that's what the record says, right? Okay.
No objection or disagreement from me, and that's why I earlier just said, whatever the record says is what you have to rely upon. I'm not testifying on behalf of the board, as you well know, but you know, my arguments and presentation is not evidence of anything. Just my view of the world.
Got it. And just because I'm not the brightest bulb in the Christmas tree, but obviously Attorney Brodsky had project representatives with him, and he has one tonight. A couple of those individuals spoke. What got me all confused, and counsel, you can instruct me if I'm going off a field, but is like, this concept of like a public meeting and that you can't have members of the planning board here to offer insight. I'm just wondering, could a member of the planning board, just a member of the planning board who is part of this decision, been here tonight to answer questions about what went on at the time, given your lack of involvement? And I mean this respectfully all around.
Yes, I understand the question.
But like, does that violate, like having the planning board here in any number, that presents like an open meeting?
No, not less than a quorum. And I'm sorry, I didn't mean to interrupt.
Yeah, no, I'm
but
just
I think
trying
I
to, I'm
understand
just
your
trying to get
question.
it out there by acknowledging my own ignorance as to that issue, because it seems like it would be helpful to have somebody from the planning board be able to sort of speak versus general references to the record, which is fine, because that ultimately the record is what we're looking at. But I'm just trying to figure out what prevents a planning board member from actually being here to answer questions.
So it's not an open meeting law issue, because we could have less than a quorum attend.
Yeah.
And that could be, a designee, or two. But the problem is, no individual speaks on behalf of the board. And so while it may seem, sort of simple, right? Well, was it on this date or this date? Well, the record will answer that question, and we can't give testimony that contradicts your record, or we shouldn't be giving that testimony. But with respect to substantive questions, why did the board do this? Well, one member can't give you that testimony, because one member can only say why they did what they did, why that individual did what they did. But you can't impute that to the board. And so I know I don't want to dive back into case law and make it a more legal discussion, but there is an issue with having an individual member of the board kind of speak to what was in the mind of the board and try to explain why people cast their votes or why people did what they did. And so one solution I might offer to the board is, if there's a specific question and you think that it merits an answer, meaning it may weigh on your decision-making or the outcome of this case, I will write it down and I will take it to the board and discuss it with them, and have the board answer that question as a board. Because one member can't do that. There could be 4 other members that disagree, and that's why they need to vote on these things. And so I'm not suggesting we prolong this unnecessarily or keep it open, but there could be a process, and I know we're getting ahead of ourselves a little bit, but there could be a process where you keep it open for the sole purpose of submitting a written response or written responses if it's a question you really do want an answer to.
All right, and the only reason I sort of go to, I have my lawyer hat on, and in my world, there's this rule, this 30B6 rule of civil procedure, where there can be a designated like corporate representative, that all answers sort of bind whatever corporation is tied to that. We're not in a court of law, so that, that specific civil procedural rule doesn't apply here. But I get what you're explaining. I somewhat get the explanation, and my fear is that if we find ourselves in a position where we would need specific, like what was in your head at the time, all this stuff was going on, if that would ultimately be more helpful or more of a pain in the butt, given that we have a record, we have the meeting minutes, we have the audio or what have you, that should put us in a position to be able to figure out on our own what went on. So I guess I don't want to I honestly don't want this particular hearing in the aggregate here to go on forever, because I guess we're also bound by certain, time frame requirements as well. But subject to, and it would have to be something that would be acceptable by the petitioner. I think we park that issue right now and allow you to continue with your presentation. Unless the board has any other concerns. Anybody? All right, hearing
Nope,
none.
I understand the board's position. I just wanted to offer that and express a willingness to cooperate with that, if that was the board's will.
Got it.
I'll leave it at that. I already spoke to the number of revisions that the board received and the timing of those revisions. And so, getting back to, I don't know if it's still up on the board's decision. Go to page 3, please. So this all comes back to the findings that the board actually made, which is what you are reviewing. And so we talked about the model a little bit. We didn't talk about traffic, I just mentioned it. The owner's unknown parcel, and then the last one is the peer review. So these are specific areas that, under the circumstances, staff and the board identified to elaborate on its position that there was insufficient and incomplete and untimely information submitted. So those are the 4 places. Now, I'm happy to spend some time on traffic. I know there was a lot of discussion on it last week. The owner's unknown.
That's a good jumping point, is that.
Which one would you like me to focus
Well,
on?
it's sort of a combination, because these, I want to be able to respect the position of Attorney Brodsky and his clients from last week, is that there was sort of a back and forth, lob of arrows regarding, certain things that are in this decision that are outside, the parameters of how you got to the decision. One being, the opening paragraph that talks about issues with, what got us here in the first place, and that's, the building commissioners or building department's sort of determination as to what the project represented. I think that I get that first preliminary matter is not dispositive one way or the other, and I think the board sort of just put that in there. And again, I'm not trying to, I'm just reading what it says. It says, nevertheless, right? So the board nevertheless wishes to note its objection to that determination. But that the issue with the building commissioner's determination, that had no bearing on the ultimate decision by the planning board regarding site plan review, right?
That is correct.
Got
And
it.
thus, the statement noting its objection, but also acknowledging that it can't rely upon that position because it doesn't have the authority to.
Got it. Okay, and then this second issue as to, outstanding concerns with the ownership of the property, which the applicant surveyor identified as owners unknown. Forgive me, in addition to like the, what needs to be, what shall, or what may be required, I don't see really a reference point to like what we would assume to be true, because how do you get to apply for site plan review unless you have the legal authority to do so? And if I recall correctly from Attorney Brodsky's presentation from last week, that issue is there's like a title issue that is on its way to being resolved. But in theory, they don't, one way or the other, but in theory, they don't have title ownership to this property. It's like, and Attorney Brodsky, you can correct me if I'm wrong here to jump in, is that it's, you have like a purchase and sale agreement, and you have, I don't know what words I can use here, but
You have
basically.
site control.
Site control, there's the word. So,
Yes.
so, thank you very much. Site control. So this issue as to property ownership, is that like a dispositive tipping of the scales as to what got this decision where it is, or is that just put in there,
Another stone on the scale,
Yeah.
is how I
Okay.
might put it.
Okay.
I wouldn't say any
Say again,
one of
it
these.
was or was not?
It was another stone on the scale. I mean, that's why
Okay,
it's
even though it's
recited.
not within their purview to look at site control?
No, it
They can
absolutely is in their purview to look at site control.
Okay.
That's a prerequisite to advancing any application before any land use board.
Okay.
And let me tease it apart a little bit more. Site control and title and ownership are different things. So the applicant has to demonstrate in any land use application sufficient site control that spending the amount of resources and time reviewing the application isn't an exercise in futility. Otherwise, you could apply for a permit for my property and everyone would say, well, what are you doing? You don't own it. You can never build this project. And so that's why site control is an important issue. It's a gatekeeping exercise. It's preliminary. But the planning board, this board, the conservation commission, the board, we're not the land court. We're not superior court. So we can't make ultimate determinations of right title and interest in any of these things. But there has to be a threshold, showing of site control. And so the reason this is recited in here, and I think this was confirmed at the last evening of this board's public hearing, is that at the time, that was a true statement, that was an unresolved issue. Now, Attorney Brodsky then represented, by way of an offer of proof, so the board is aware, not part of the record, but, fair play, just so the board is aware, that he now believes that's resolved. And so to the extent it was an issue, it's not really an issue now.
But just to put the issue to bed, these sort of the anecdotal stuff as to the building commissioner determination, the ownership, though it may not be specifically sort of codified in chapter 410-4.1, nothing within 410-4.1 specifically, subsection 5 that talks about what the board can do, nothing prevents, in the same sense that the board actions section doesn't obligate the board to make a finding and then put a footnote as to where that finding came from or what have you. Nothing prevents or obligates the planning board to put one thing or the other in its decision, right, based on the bylaws. So there's some movement, there's like some interpretation that can be applied by the planning board as to what they want to put in the decision, as long as they follow the 410 bylaw.
If I understand your statement correctly, and I'm not sure I do, but if I do.
That's fine. I've asked a ton of questions today,
no,
so I'm running out of.
I just don't want to swing and miss because I do want to be responsive. Yes, of course, the planning board has, in conjunction with staff who they worked with in this case, it may be council in other cases, can decide what the contents of its decision is going to be, which may mean that one particular issue is escalated to the one and only dispositive issue, or it may mean that there's a litany of 25 different issues. The board always has the ability to make that choice, guided, of course, by their legal requirements in drafting, voting, and issuing that decision. But sure, and there are, of course, some decisions that have one reason. The applicant failed to appear and prosecute their application, so it was denied. So maybe that's a one-sentence decision. Other ones, like for example, a comprehensive permit, might be a 50-page decision, and so on and so forth.
Right. So at its core essence, it can be for one. A denial can be for one, targeted, focused issue. Like in this case, the lack of a 3D drawing. If we're just using that as an example. So one failure on part of the applicant to provide something that was requested, the planning board has the discretion to deny that application, even based on something that may seem superficial in the overall scheme of things, versus a decision to deny needs to have 3 or more reasons as its basis. Like it can be 1 or it can be 100.
Potentially, and just going back to the conversation we had at the outset about the difference between a grant and a denial, and sort of why there's a lesser standard when a court reviews a denial for looking for those reasons. And the Davis v. Chatham case that I mentioned, and this is just a quote, even when a zoning board cites no particularized reason or any specific evidence for its denial decision, its action will be upheld if a rational basis for the denial exists, which is supported by the record.
Got it.
And so that's how it all comes back.
In a special permit case.
Yes, but that's true in
But
You
the,
can look at-
but the standard in prudential is different for a by right use and a
It will
approval or
be-
denial by site plan review
It will be
for a by right use.
extraordinarily more critical in a
Right.
site plan by right case, yes.
Okay,
Yeah, and again, that's where we started,
so
and I'm not gonna,
it's not, nothing
Argue the law
delineates
isn't
it.
the
We don't
law.
have a statute about like how many points you have to make.
not yet.
But,
There's one in the pipeline.
but understanding how the standard applies to a by right use site plan review, not a special permit. We can look at the way that the planning board comes to its decision and how it expresses that decision as being sufficient, sufficiently, threading that needle, as I said.
Right, and again, if you determine that there was a rational basis in light of all the arguments you've heard, you could affirm it. If you determine that that might be a good argument, but it's not supported by the record, then maybe you don't.
Okay.
And so I'm happy to engage in this further, but I feel
That's helpful.
like
No.
I'm going a little bit beyond my lane because you have counsel and I'm not your counsel. And so
Understood.
I don't want to be giving the board sort of my view of the legal, context of this. You're going to get an opportunity to speak with your own counsel about that, and your counsel may have a different view of it, and that's perfectly fine. You get, how many lawyers? 4 lawyers in the room? We might all have a different,
5.
maybe 5, maybe more. Anybody raise their hand? And so I get that. And
Okay.
so this is just my view of the world, as I stated earlier.
Got it.
And I guess it's helpful that, to my point, that absent somebody on the planning board speaking to what went on, we have to rely upon you as their counsel. Okay, so that's fine.
Yeah, and that's also why I'm being a little mindful to not testify on their behalf. If I don't know, I think I've tried to tell you, I'm sorry, I can't answer that. Or I'll say, I would expect, as opposed to, this is what happened. And so if there's any confusion about any of those statements that I've made, please understand, I wasn't there. If I know the answer, I will give you the answer to the best of my abilities. But if I don't know, I'm not going to supply one because I'm standing here. The record will ultimately speak for itself. And if you find that I said something and the record doesn't support that, you will speak with your counsel about how to reconcile that. So I want to get back to the owner's unknown, because just to correct a statement from my view, I understand Attorney Brodsky represented sort of where the current disposition of that case was, and that at the time the planning board made this statement in its May 19th written decision, that was a true statement, but it had since been resolved. On August 7th, that court decision, a notice of appeal was filed in it. And so I don't know the facts and circumstances of the case. I understand from looking at the docket, there are over 300 entries on the docket. I'm not counsel in that case, so I'm not going to represent to you what the public record is. If there's an interest, you're welcome to look, but I will tell you that that's not resolved. On October 7th, that decision was appealed. And so what that means, I don't know, but that is still an outstanding issue. It appears from that public docket. So that's the owner's unknown. And then I know we've sort of touched on traffic, but haven't talked about it. I'm happy to if you want. I only really want to make one point about that, because I don't disagree that in the face of expert evidence, the best course of action is to have an expert agree, disagree, refute, whatever the case may happen to be in that case. But the very cases Attorney Brodsky cites in his supplemental memo that I received yesterday at 4:40-ish, and I think the board just received more recently, there are cases cited on this point. And they stand for that proposition that you can't just cavalierly and offhandedly reject an expert opinion. Sure. But it also doesn't mean you check your common sense and your knowledge of your community at the door either. And so a board can be critical of expert submissions and can ask questions and can say, that's not consistent with my experience, and I've lived here for a great long time, and I know this site, we drive by it all the time, and I have concerns. That is allowable. Now, can a layperson, and you know what I mean by that, just someone who doesn't have a professional degree in that subject matter, so traffic engineering, et cetera, can a layperson say, I've looked at your data calculations and your methodology and I disagree? No, probably not, right? And neither could I. I'm not qualified to give that testimony, and I wouldn't. But I could tell you that if I lived on a street and I knew exactly what goes on that street, that I might have an opinion on how something might affect that. And so how do you resolve that? How do you get from one to the next? You have a peer reviewer, and you voice your concerns to the peer reviewer. There's a back and forth and exchange, and ultimately the peer reviewer issues a letter saying, I'm satisfied, I'm not satisfied. There are outstanding issues, they've now been addressed, and I'm done with my review. Here's my closeout letter, please proceed. That didn't happen. There were outstanding issues in the view of the planning board, mind you, that didn't get a conclusion because the hearing ended the way it did. So that's what that's third point is. No, excuse me, second point. So the model, the traffic, the owner's unknown, and so that's the only point I wanted to make about that. I know the applicant disagrees, and the applicant believes that it has submitted sufficient information that would allow the planning board to cross that item off its list. The planning board disagrees with that. The planning board wanted to continue the process to take the updated site plans, the updated traffic response, and all the other pieces of information that they got on April 29th, spoke about it for the very first time on May 14th, but they didn't get that extra chance to have it reviewed and close it out. They asked for 2 more public hearings and then a further date so that that could be accomplished in a reasonable time frame. The applicant thought it could happen in a shorter time period. That disagreement led to the end of the hearing. That is borne out on the record.
All right, and in terms of what you've just sort of presented, I want to back up just a little bit to sort of reconcile that section in the decision as it relates to traffic conditions. And this is also sort of, you know, reference, and if this isn't applicable, you can tell me, but in your letter that was submitted, that's in the record, it's this July 21, 2026 letter, you also reference, I think, an important aspect of the bylaw, and this is 41C subsection 8, and this means administration, and it states that the planning board shall be responsible for deciding the meaning or intent of any provision of this section which may be unclear or in dispute. And to the extent that it's relevant or irrelevant to what you just said, what I'm trying to confirm is that, like, the bylaw says what the bylaw says, and essentially what this subsection 8 administration means is that sort of the buck stops with the planning board, is that they have the right, pursuant to this bylaw, to interpret, digest, relay, explain, or what have you, anything that is before section 8 as they see fit. So is that what I'm talking about here? Is that they?
Yes.
Okay.
That's right. And so, you know, nothing's ever been written so well that no one ever had a question on it, right? And so bylaws are susceptible to that like anything else. And so that provision, which town meeting, you know, adopted, and so the town imposed this requirement on itself, allows the planning board the discretion to resolve discrepancies and ambiguities. That's what that paragraph means. It vests in them the authority to do that. And so when they review things like the items that we've listed, the model, the traffic, the owner's unknown, et cetera, those are the kinds of things that they're saying, when we get these things sent to us on April 29th, the only meeting we know for certain we have is May 14th, and we don't believe that that is sufficient for us to do our jobs as planning board members, elected planning board members, then how can we grant an approval when we don't believe we can even make these findings, that we're in a position to? So that's how it all zippers back together.
And then one example that could sort of buttress what you're telling me here, and I'll ask a follow-up, is that we also have, and Attorney Brodsky, I believe this is, I got it wrong last week, but I think it's Exhibit 12 from your materials. It's a May 12, 2026 letter. Let's see, Renee, if I get this thing right. Big money, no whammies. Anticipation is killing me. My favorite thing about being a lawyer is the awkward pause or silence. I love that space more than anything on earth. Okay, so here we go. All right, it looks as though I'm looking at the same thing. Is that what we have here is a May 12, 2026 letter, again, sent by Attorney Brodsky on behalf of his client, email, first-class mail. You know, obviously, who knows if the first-class mail would have arrived by May 14. Email, I imagine it came whenever he sort of emailed it. We don't have sort of the email cover page. But this letter indicates that Attorney Brodsky, on behalf of his client, submitted a transportation memorandum prepared by CEC Inc., dated the same date, May 12, 2026. So this is, you know, for lack of the backstory to the continuance and what I talked about earlier, is that absent the continuance and the discussions about subsequent meetings, is that the planning board had a meeting that was duly noted, properly noticed, or what have you, for May the 14th of 2026. And just 2 days before, whatever the time may have been, if it's like literally 48 hours or less, we have a transportation memorandum submitted. Now, Attorney Winter, would it be the planning board's position, to the extent that you know that it's not as simple as like, oh, here's this transportation memo, we can review, digest, or what have you, and be ready to sort of talk turkey about it on May 14th? Or would this been a situation where the planning board would have sent this transportation memorandum to whatever expert or whatever they've got on their side to digest, review, and compare with prior transportation reports or what have you?
Can we clarify, this is a supplement that came on May 12th. The actual traffic study, correct, was submitted quite a bit earlier.
Yes.
So
Yeah,
the
yeah.
primary traffic
Right.
study.
This was
So
a
this was a
supplemental.
supplement.
Right,
So it
responsive
wasn't
memo.
necessarily gonna go to every single person who might review the traffic study. It was a request for additional sightline measurements, is that right?
And that's a fair question. What I'm just trying to, at its core, yes, if you look at the decision, there's reference to transportation memos, you know, 4/1/2026 revised 5/12/2026, and then email, it actually says 5/13/2026, so a day before the hearing. But I imagine that it's not as simple as having to sort of interpret and review whatever is in this supplemental transportation memorandum on the fly. So you go to the meeting on May the 14th, and that's like your first time collectively, you know, reviewing this. Would it be the planning board's position that this transportation memorandum supplement, or however you want to describe it, that there, you know, simply wasn't enough time to actually flush out any compliance issues or, you know, any responses or a request by the planning board for more information? Just like contextually, like getting something 2 days before a
Understand.
hearing, is that a problem?
It is a problem. And all I'm going to say in response to that, because I don't want to pretend that I can testify as to what they were thinking at the time. You can listen to the recording of the May 14th meeting, and you can read the decision, which means 2 days later. Now, whether they received that in real time or they received it for the 14th, or on the 14th for the first time, they still voted unanimously to make a finding that there were outstanding concerns on this topic. That's all I can tell you, because that's what the record says. Now, the normal order of operation would be for the person in charge, whether that's peer review or someone else, to check the box and say, whoa, this is a 20-page memo and I'm going to need time to review it, or this is one sentence or one paragraph and I can tell you right now over the phone I'm fine. But in 2 days,
absent that sort of like if so, but so, like, you don't know the answer to that question. It's again referring to what's in the record for us to sort of,
and that's why I tried to answer it in 2 parts.
Got it, okay.
My first answer was I can tell you what the decision says on that topic, and that decision was voted unanimously just 2 days later.
Okay.
The second half of that was my view of the world, yes.
All right, and I guess as it relates, and you may have touched upon this a short while ago, but I recall, Attorney Brodsky, calling into, raising the concern that first sentence in the 5th paragraph there, that the board also finds that the traffic condition primarily at the intersection of Fitzpatrick Way and Nantasket Avenue will be negatively impacted and create a dangerous roadway condition. And I, full stop there. Now, that statement, and from my legal brain, I sort of get where Attorney Brodsky was going, is that as a standalone statement without an anchor point to some document that confirms
Or
the
data.
statement to be true, or data set. Like, is it the planning board's position that, and forgive me if you already explained this, but is it the planning board's position that that it's free to sort of include their own interpretation of what goes on the ground here? Is that if there were, that they need not reference some sort of report that challenges what these transportation memorandum supplement or what have you otherwise, that they don't need, that the planning board doesn't need an engineer's report that supports this position that a dangerous roadway condition will be created. Is that accurate?
If I understand your question correctly, I think there's 2 levels here. One is, are elected planning board members entitled to have a lay opinion of what's going on in relationship to this site? And are they entitled to say that they find the traffic condition would be negatively impacted and create a dangerous condition? And as a lay opinion, sure. I don't see why they have to check their opinions at the door simply because they're not traffic professionals. Now, had they gone further and said, and we disagree with the calculations, the analysis, the means and methods, the modalities, the level of service conclusions, that's a professional opinion, and that would certainly be something I would consider out of bounds. But if you read this paragraph in context with everything on this page, I read it to be a little bit differently. I don't read it to be them attempting to make an expert finding. I read it as them in trying to explain what they mean in the second paragraph, that there are unanswered questions. We have serious concerns about the traffic condition, primarily at this intersection, that we think will be negatively impacted and create a dangerous condition. That has not been addressed sufficiently for us.
All right, and then if I'm,
Again,
So
that's
could I-
my interpretation, but you're all reading the same thing as me, and you're welcome to your own.
Could I see if I can clarify the, this paragraph as written doesn't reference the traffic studies that were submitted or the peer review of those traffic studies, correct? So we don't have necessarily a way to identify what was deficient about the traffic question that allowed their finding as a lay opinion to be the one that, so I mean, I think it's unclear what was deficient in the actual scientific and professional traffic studies that would have allayed, would have allayed the fears. My concern is that as written, it's sort of like the bar, I mean, how do you even know what would convince them? If you are carrying an opinion, lay opinion, that you're entitled to have, and it's contrary to what professionals are saying, and there's no discussion about that, reconciling those two things, it gives me a concern about whether that could ever be satisfied.
And this, let me just try to make it like follow up on that one. I guess and forgive me if I'm overlooking something that's in the record, but did the planning board have their own traffic study at their disposal at the time this decision was rendered on May 19 that would have served as a, point-by-point counterpoint to the transportation memos, supplement or otherwise, that were submitted by the applicant?
I'm not able to answer that.
Okay.
I believe Attorney Brodsky testified to the status of the town traffic study that
was
available.
after the fact,
I
right?
believe he said it was after the fact.
Okay, and then to bring it back to the bylaws itself, 410-4.1D design guidelines, it says the following specific items may be considered by the planning board in making its decision. And then if you go to subpart C, it says convenience and safety of vehicular and pedestrian movement within the site, the location of driveway openings in relation to traffic or to adjacent streets. Now, as it relates to that design guideline subpart, does that leave open to the planning board to either, consider only what's been submitted by the applicant and then reconcile themselves without the need to defer to a separate report that may challenge these issues? I'm just wondering if this, Rebecca notes her concern about this sort of, standalone statement here, not being married to something, but as the decision is written, is it your position that it's in compliance with the design guideline requirements, specifically this D1C?
In 2D, I believe, or D2D, is also cited in that paragraph. And again, I hope I'm understanding your question, but yes is the answer, because I believe that the planning board is not required in its written decision to articulate every single criticism or concern or position that they hypothetically may have taken were they to write a lengthier decision. That's not the standard of drafting. They're elected members of the board. I'm sure you're familiar with all of this, and I apologize for saying things you already know. And they're not held to the standard that judges are held to. That's the state of the law. And so they have the assistance of staff, professional support through peer reviewers, at times counsel, but they're not held to a drafting standard the way the United States Supreme Court would be, or a local judge here. And so the citation to the bylaw requirement, two bylaw requirements, and some exposition about why they're citing to those needs to be looked at in conjunction with the record you have in front of you. And so in isolation, if you were only looking at this decision, you wouldn't know the answer to that question, and that's why you have to review the record as well. And so you'll recall the quote that I had read, and I'm sorry I keep quoting cases, but it was, even if the board did not cite a reason, if the rational basis is apparent on the record, then its decision can be affirmed. And so if you read this condition, or this finding, and if you review the record and you determine that there's a basis for it and the basis is rational, then the planning board did its job.
Okay. Now, and again, I think you've sort of made your point with reference to the specific bylaws here, but just like when the decision notes that the number of vehicles traveling southbound on Fitzpatrick Way and making a left turn onto Nantasket Avenue directly adjacent to this site will increase as this will become the only access point. Is that, to the extent that you know, that statement, is that based on what I presume to be a review by the planning board of these various traffic studies, supplied by the applicant?
In conjunction with the plans that they have in front of them. And so I'll refer you to section 2D, drives, parking, and circulation, which specifically mentions access points. And so, yes, evaluation of sightlines and a turning radius and other sort of engineering calculations is probably something that a professional should do. But counting access points and having an opinion of whether they've been sufficiently identified and whether there's a sufficient number is something a layperson can do. They can look at a plan and see if those exist and if there's been sufficient information to describe them. And of course, that's why things get sent to peer review, to then answer the other questions.
Gentlemen, down at the end, do you guys have any questions based on the murmurings that I just heard?
No, it just seems that we're covering this issue again and again.
Okay. Yeah, understood. That's fine. And yes, Tony, if you want to, I take that point, and we're just trying. So Rebecca and I are sort of the ones leading the charge on questions here tonight. So I just wanted to, keep things moving forward here. All right. So as it relates to the traffic issue, have we exhausted, your explanation of how we got to this finding in the decision?
I believe I've made the point that I wanted to make here tonight. If you have any other questions, then I'll leave the traffic issue.
All right. And then I guess moving beyond that, we've covered the ownership issue. And then I know we touched upon earlier is that lastly, so the final finding is lastly, the board also notes that the applicant refused to submit the funding necessary for peer review, which the board reasonably requested under 410-41.C3G, which, if we look to that, it's should the planning board find it necessary to seek advice or assistance, it has the authority to employ professional consultants or experts, including technicians, attorneys, engineers, and/or architects for the purposes of reviewing and evaluating on its behalf the information shown on the site plan and any additional material. The cost of such professional assistance incurred by the planning board shall be borne by the applicant. However, the cost to be paid by the applicant, 1, shall not exceed the reasonable and usual charges by the consultants, and 2, shall be estimated in writing by the consultants and made known to the applicant before the board incurs any costs. No occupancy permit may be issued by the building commissioner until the applicant has paid or reimbursed the town for all such costs. Now, this issue, and you can sort of just, offer some additional insight into it. It appears that the issue over, funding for peer review was addressed in Attorney Brodsky's letter of April 24, 2026, which I believe is Exhibit 14 as part of his presentation. Can you explain with any more detail, the basis for that? And if you've already offered statements, my apologies, and anybody on the board can tell me we already covered this, but can you be specific to the extent possible when it says the board also notes that the applicant refused to supply the funding necessary for peer review, which the board reasonably requested? Now, can you elaborate on that? What was requested and what wasn't done allegedly by the applicant, or what wasn't agreed to?
So my understanding in speaking with my client is that refers to two things. And I'm just going to apologize in advance because I know you're going to ask me, specifically, what items were they going to have peer reviewed and when and what was deficient about it? I can't answer that question. I would have to take that question back to them. What I can tell you is that it refers to a lack of clarity with the materials that were provided, revision dates that came in, further revision dates, no ability to track them, dates that skipped, plans that didn't have dates. They didn't know what the peer reviewer was supposed to be reviewing at times, so a lack of clarity. And the second is the reason why they wanted to continue the public hearing more than just one night was to provide sufficient time for those exchanges to occur. And so the planning board members believed that they lacked the expertise themselves to make those decisions on their own, and sought additional time to receive, understand, transmit to professionals when necessary, and get a response from professionals when necessary, thus the request for 2 hearing nights. And that's, I know the sentence is sort of lying naked there on the page without any context. That's what I'm informed it refers to.
It's, just to clarify, because I think it's confusing, because it seems like it's a black or white. Like it's either there was a bill in front of the applicant that they paid, or there was a bill in front of the applicant that was not paid. And so I guess the question is what bill was put in front of the applicant, or what projected bill? Like, we need X, we need you to pay for it. That's a black and white. What bill was put in front of the applicant that was not paid?
I don't disagree, that's how it reads.
Okay.
But I'm still not in a position to answer
You don't,
that.
we don't know.
And how about this, though? So what we do have is this letter from Attorney Brodsky. I do this all the time, but like it's the Exhibit 14, is that what we're looking at here? Obviously, it says April 24, 2026 on the cover page of the letter, and then the subsequent pages have a March 4, 2026 date in the top left corner. So I'm gonna just presume, since I've done this a zillion times myself, that the real date that the board received this, or that the letter was sent, was April 24, 2026 versus March 4, 2026. But specifically on the second page of the letter, this appears to be in the third enumerated paragraph, Attorney Brodsky's sort of response to this issue with peer review funds or what have you, and it appears to be tied specifically to this alleged issue that the planning board may have had an axe to grind with the building commissioner as to the zoning designation. I guess to the extent, if you know Attorney Winter, is there something separate besides, what Attorney Brodsky says is, it's not the applicant's role to fund this issue, that the issue that the planning board may have with Mr. Kelly's determination as to zoning is not what this particular bylaw 410 4.1 C3G is meant to be. Is it something beyond or separate from that just simple issue that the board had a concern about the building commissioner's zoning determination?
So I can tell you, just based on the 4 corners of the decision, that the answer is yes, because the first paragraph after findings explicitly disclaims that that's what they wanted to do. It notes that they had a concern. That's on the record. They had a concern. They sought counsel. They received that guidance with respect to that, and they noted in their decision. And so they specifically have rejected that argument, knowing that Attorney Brodsky and his client have raised this, and they stated so. And so I think the only way to interpret the last sentence of that finding section is that it didn't have to do with the first paragraph. Otherwise, why write both?
We do not know whether even the statement is factually correct or incorrect.
The record will be the record.
Okay.
And again, I stated before, I'm not in a position to answer that, and to tell you what bill was sent to who and what happened
Whether it was
to it.
paid. Okay.
I just don't know those facts.
Yeah.
But you have the record, and if it's supported by the record, you can draw what conclusion you will from it.
Okay, and then just to bring it to a conclusion on this issue, what we do have is a bylaw that is silent on the format of the decision. We've talked about this 1,000 times tonight, but you know, in hindsight, would it have been helpful for the planning board to be a little bit more specific? Sure, but it's the planning board's position that the bylaws are what the bylaws are, and as long as they're adhering to the bylaws, and that it follows any legal precedent as to the interpretation of these bylaws, then the decision is valid and good to go.
So if I could just make one last statement, and just to
Sure.
bring it back to the very beginning, and then I'll stop. And it's just to sort of remind you where I started with this presentation and argument. And I never said that this is a project that will never get a permit or has to be denied on its merits. The position of the planning board is that it fits within that footnote, that narrow exception, because of the timing and the way the hearing went when they got 6 pieces of information right before the last evening. They didn't get the continuance they asked for, they got something less, and the planning board took a position that it had insufficient information, that it didn't have sufficient time, and in that situation, the planning board has a Sophie's choice. It can either capitulate, go into the last night, and just give it their best shot, right? And say, well, I don't think I understand this, I'm not sure this is even sufficient, but we're out of time, and staff has prepared a draft boilerplate set of conditions. Let's see if we can just stitch it together and do our best. Or they can say, no, we don't want to do that. We want more time. We asked for more time. We didn't get more time. And so I don't, as a voting member of the planning board, I don't feel I have the ability under these circumstances to cast a vote yes. So that's where I started, that's where I want to finish, and thank you for the time. If there's any more questions, happy to do my best to answer them, but I'll leave it at that for now.
All right, and listen, I don't want to exhaust this evening any further than we've gone, but I want to get on the record here. One final sort of analysis is that in addition to all of the other bylaws within 410 that we've discussed tonight, there's this subsection, C4, that speaks to the review process, and there are 4 subcategories as to what the board is obligated or has discretion to consider. Obviously, when it says the planning board shall hold a public hearing on any properly completed application within 65 days after filing, and shall render its decision within 105 days of the filing. Obviously, there was, a meeting of the minds and a collective effort that both sides would agree that that the 65 days and the 105 days would be a moving target based on the complexity, right? Okay, so within those confines and the agreed to extensions that could have conceivably brought us past May 19, 2026. These 4 subcategories, again, to bring it back to the beginning for the board as well, us, there is, the first section is A, upon reviewing a completing application, the planning board may seek the comments of any of the town boards or staff, etc. And then B, within 35 days of receiving a copy, these agencies shall report to the planning board on the adequacy, etc. Subsection C says the planning board shall not render a decision on an application until it has received and considered all reports requested from town departments and boards, or until the 35-day period has expired, whichever is earlier. And then the final subsection D says, in reviewing the impacts of proposed development, the planning board shall consider the information presented in the application for site plan approval. So focusing on the shalls, just as an example, subsection C, planning board shall not render decision until it has received and considered all reports requested from the town departments. As you sit here today, or tonight, Attorney Winter, like, did the planning board consider all requested reports from town departments? I know in the record there's a zillion sign-offs by various, town departments, boards, et cetera. But is it the board's position that any reports from town departments and boards were outstanding at the time this decision was rendered on May 19?
None are recited in its written decision.
Got it. And then, to the same extent, in D, in reviewing the impacts of a proposed development, the planning board shall consider the information presented in the application for site plan approval, all reports of town departments submitted to the planning board, and any additional information available to the planning board, submitted to the planning board by any person, official, or agency, or acquired by the planning board on its own initiative or research. There's a lot going on in that subsection. But is it the planning board's position that it considered everything in the kitchen sink, both from the applicant, from town boards, from the public, et cetera? Like nothing was left outstanding?
I have no reason to believe that the planning board didn't consider the totality of the record that it had, which is quite similar to the record that you have, which is extensive. Hundreds, if not thousands of pages, I imagine. Other things, sheets and emails and things like that. I have no reason to believe that they didn't consider that, and in fact, I have every reason to believe they considered it in extensive detail, painstakingly so.
Got it. So the list of things, in front of this decision that speak to, the plans and materials, that, without a planning board member here to confirm, all of these documents identified in plans and materials were what they considered ahead of rendering this decision.
Yes.
And that would include town department comments, design review board reports, public comments, et cetera. Is that accurate?
Yes, and keep in mind, while the minutes are available, the recordings are also available. And so public comments, minutes don't have to be a transcription. And so the recordings are very illuminating as well, because the board, the last sentence, of course, there's a lot going on in paragraph D, but there's references to information presented in the application, all reports, any additional information available to the planning board, submitted to the planning board by any person, official, or agency. That could be testimony of the public at the public hearing, and acquired by the planning board on its own initiative or research. So irrespective of the source, it would have to come back to the public hearing. And so it would have to be discussed at the hearing. And so considering the number of nights and the length of these meetings, that's a pretty extensive record, but still resulted where it resulted.
Okay. All right, Attorney Winter. I don't know, anybody else on this board besides Rebecca and myself have a question? All right, hearing none. Attorney Winter, do you have anything else to offer as part of your presentation, or do you want to close that portion of this process?
I will sort of reserve on any further questions that may come up or the board may have, but that concludes I think we were calling it case in chief. So I'll leave it at that. Obviously, I'll be here to answer any further questions that come. I don't feel any need to respond to the offer of proof that I received yesterday. Maybe you
Nor do I
received
want
today.
you to.
So just for the record, I'm not going to address it unless the board instructs me to. I have no unique desire to, so I'm not asking for that permission, but I'll stop.
Got it, okay.
And then if there are any follow-up questions by way of written responses to your questions, please just let me know before the conclusion, and I will get you those answers if the board even desires to do that. So I'll leave it at that. Thank you.
Delightful, thank you. And right now, given the hour of the evening, I'm going to ask for a brief recess, both for those in the audience who may need to use the facilities or just want to not stare at me any further for a little bit.
5?
Yeah, like let's do like 5-7 minutes, because I want to discuss with council
what happens next, okay?
So do you want, I go for 7-minute recess?
We'll do a 7-minute recess. How about that?
All right, gang. We are out of recess. We are. I think we have the important people who are here. This is what has been discussed and confirmed as it relates to what's going to happen tonight. So, at the agreement of both sides, attorneys Brodsky and Winter, we are going to proceed tonight for just a little bit longer, so that each side has the ability to do what lawyers like to do, which is talk, and basically provide a closing statement as it relates to each respective position. They don't have to do it. One may do it, one may not, but we want to sort of complete this part of the process so that we can close this aspect of the case. And without putting words in either Attorney Brodsky or Attorney Winter's mouth, is that an okay plan for tonight while we still have,
Chair Hennessy, I was not planning on providing a closing. I simply wanted several minutes to respond to several of the factual issues that was raised in your questioning of Mr. Winter, because I have the answers to some of those questions that he did not know.
Okay.
Probably will take 2 minutes. What I would ask is that at the conclusion of that, and then again, Attorney Winter will speak for himself, I'm happy to waive closing arguments. I'd ask that the board please close the public hearing and deliberate tonight.
all right, we're not going to deliberate tonight, but what we will do is we will factor in either what could be classified as a rebuttal or a closing statement, and then once we get through that portion, we will make a motion to close what's the term again?
We close the presentation.
The presentation aspect.
Hearing and continue it for the discussion and deliberation.
Okay,
of the board
got
to
it.
a Future date.
To a future date. Okay. So that's my position on behalf of the board. So as we sit here today, shortly before 10 p.m., I will welcome Attorney Brodsky to provide, up to 10 minutes or whatever he needs to address what Attorney Winter has said tonight, and then I will give Attorney Winter the option to do the same, and then we'll go to the next step. So, Attorney Brodsky, the floor is yours.
Chair Hennessy, could I address you from my seat here?
You absolutely can.
So very briefly, with respect to the list of unresolved items that was attached to Attorney Winter's July 21, 2026 letter, I would just note that this list was never provided to my client. The list was not discussed at the final meeting of the Planning Board on May 14th, and this list is not referenced in the decision issued and filed with the town clerk on May 19th. And this list is replete with factual errors. So for example, official traffic study not performed. I provided in my supplement the colloquy with respect to traffic. It was agreed to that we'd provide a transportation memo, which we did. We were never required to provide a traffic study. These are terms of art. I disagree entirely with the premise that lay people can opine regarding traffic, which is subject to federal safety standards, but that's a separate issue. So I want to make that point with respect to that list. Second, I believe Attorney Winter said that at the May 14th public hearing, the Planning Board reviewed and discussed a draft approval and a draft denial. I provided you with yet another copy of the minutes from May 14th. I believe it's exhibit number 1 to my supplement. There was no discussion regarding a draft decision either for or against. In fact, if I recall correctly, the Planning Board was smarting because they claimed not to know that the planning director had provided my client with draft conditions, which we turned around and provided comments in anticipation of appearing at that meeting. And we did not appear at the request of town staff. We were prepared to address conditions. We were prepared to present the final traffic memo, and I'll just expand on that quickly. Second, with respect to revisions to plans, my clients are not in the habit of willy-nilly making revisions to plans, which are very expensive. Each and every revision to the plan was either requested by the planning board, a member of the public, Mr. Chesia, or town departments. The suggestion that my clients somehow made revisions to the plans that were not requested is not supported by the record.
Back, just to pause there, when you made reference to, and I'm sorry if I missed this point, but you said that that the team, your clients, nor you appeared at the May 14 hearing at the request of town employees?
So we intended to present all of the final comments that we had submitted, and intended to negotiate final conditions as we had previously agreed. And as we said, we received a request to continue that hearing on account of the town election. All of that information is provided to you in our written materials. So you need to remember the context. We, in a spirit of cooperation, agreed to do so, but we were perfectly prepared and ready to attend that public hearing.
Understood. Okay, continue.
Third, there were closeout letters. John Chesia did provide his final comment letter, and CEC provided final comment letters. I believe I provided a copy of that to you in my supplement. They're all in the record. That's CEC's April 30, 2026. I think it's Exhibit 3 to my supplement.
So Chesia and CEC, or is Chesia the same thing as CEC?
No, Chesia was the town's peer review
Yeah.
consultant who issued final comments. CEC was our consultant who issued final comments. And that's a summary of all of the public comments and how each and every comment was addressed. So you have final closeout letters. Again, we were prepared to close the public hearing and anticipated getting a site plan approval. I just need to be clear, you need to distinguish between site control and title issues. Just so you know, the application for site plan review, which was attached as Exhibit 5 to my original submittal, was signed by the property owner authorizing us to file this. We had complete site control. We had also explained to the planning board that the property is under a purchase and sale agreement, and that there was a permitting contingency, which is standard for real estate development. The suggestion that we did not have site control is not accurate. Again, I've explained the title issue to you. It's completely outside of the purview of the planning board.
I get that. I don't think it's really like,
All right.
ultimately a tipping point. Hold on. The decision doesn't mention site control. It just says there's outstanding concerns with the ownership. So we may be splitting hairs on that, but I don't think.
We're not splitting hairs. The fact that was included in the decision, again, as we say, demonstrates the planning board's true intent here.
Well, hold on. I mean, listen. As we've discussed.
This is my opportunity, Chair Hennessy.
Yeah, understood,
I
but-
think this evening has been patently unfair to my client.
Oh, sure.
Ms. Rogers would ask a pointed question. You would not let Attorney Winter answer it. You would reframe the question.
And guess what?
In a way.
This is our hearing tonight, Attorney Brodsky. So I'm giving you the respect of allowing you to sort of wrap this thing up. But I just I can't. I would be I'm negligent in my role here tonight to not allow your closing argument to add inflammatory aspects to this. So just be very careful with your words and continue. That's all. And leave the
Chair Hennessy,
fair what fair.
These are not inflammatory comments. These are facts that I'm reciting to you. I'm just indicating
But
a
to say that
pattern.
there was like some preconceived, decision in the planning board. The regs we discussed all night long. Nothing prevents the planning board from putting whatever they want in that decision.
So, again, I'm going to divert you, and you're not going to like this. The Attorney General has reviewed that site plan bylaw and has opined to the town that it needs to be very careful in applying that bylaw to permitted uses.
Sure.
And I gave you the evidence of that opinion.
Today, that is not part of the record. So I'm not factoring
absolutely is part of the
this in.
record. So-
No, it isn't.
So we can discuss it. If the Zoning Board of Appeal doesn't want to consider an Attorney General's opinion regarding the applicability of this site plan review bylaw to permitted uses, that's your discretion.
Understood. Thank you.
I just want to talk about traffic briefly and just to remind the board that traffic was reviewed by CEC's traffic engineer. We received comments from the police department with respect to traffic, and while you don't want to recognize it, the town's own recent green traffic study corroborates everything. The suggestion that lay people can just offer an opinion regarding traffic, which is typically the subject of expert testimony, I don't think is supported by the case law. I provided you with case law that even if a board member wishes to reject uncontroverted expert testimony, that they have to explain in the decision why they rejected that uncontroverted testimony. That was not done in this decision, and for that reason, that provision, that finding is inadequate as a matter of law, and alone requires remand. As I've previously told the board, despite our objections regarding the scope of Chesia Consulting's review, we paid all fees. There's nothing in the record regarding the failure of the LLC to pay peer review fees. I don't know why that's in the decision. It's factually inaccurate. If someone can point me to anything in the administrative record regarding an unpaid bill, please do so. I don't think you're going to find it. Again, that's an indication that this was not a careful deliberation concerning the totality of the record by the planning board. Is yet another indication of why this decision is suspect. So with that brief summary, we request that the board please close the public hearing and deliberate this evening. I don't think it's going to take very long for the board to reach its decision. To require that I have to attend and others have to attend another zoning board meeting in order to listen to a deliberation, I don't think is fair to my client. It's been expensive enough. Thank you.
Understood. Attorney Winter.
Thank you, Mr. Chairman, and again, Brian Winter on behalf of the planning board.
Thank you for the opportunity, but I'm not going to provide a rebuttal or a closing. I had the last opportunity to speak at the lectern and answer your questions, and I'm satisfied that I've articulated the points I wanted to make. With respect to sort of recross or redirect or whatever it would be if I responded to Mr. Brodsky now, I feel like it would just prolong a debate that isn't particularly meritorious at this stage of the game. And so thank you for the opportunity, but I'll rest.
Okay. All right. Council, now I make a motion to close.
Yeah, you can make a motion to close the public hearing or presentation portion of the appeal. And then you can make a motion
Okay.
to continue the deliberation discussion portion to a future date.
Got it. Okay.
Just a quick, thank you. No new material can be entered after it's closed, so. If the board has any additional questions, I will be able to ask.
Correct.
And if we all get the plague, it's Renee's fault.
It's just a reminder, there are 2 appeals.
What are we talking, the building permit?
Building permit.
Right. Okay. So.
Thank you.
So, okay, I'm going to make a motion to close what was the term again? My brain's.
Public presentation.
I'm gonna make a motion to close the public presentation aspect of these appeals tonight. Do I have a second?
Second that.
Okay, so motion by Hennessy, second by Parsons. All those in favor, roll call vote. Aye. Aye, Hennessy.
Aye, Parsons.
I may.
Okay. All right, so both gentlemen, thank you very much for the time that has been spent on this. I greatly appreciate, even though it's fun to sort of argue about stuff, I greatly appreciate the efforts that have been put into this by both of you. I respect you in the highest regards and really appreciate what's happened. With that being said, to put a pin in your balloon, Attorney Brodsky, I'm going to make a motion to continue this hearing for purposes of making deliberations to a subsequent date that works with all parties. Council, I don't know if that motion sounds right?
Deliberations and
Can I,
discussion.
can I ask a question? Are deliberations a public
Yes.
meeting?
Yes, it's all in.
But it's just conversation among the zoning board members?
Correct.
Okay, so no input from elsewhere, okay.
Yeah.
I think we need to continue to remain specific.
Yeah, exactly.
Otherwise, we'd have to re-advertise.
Right, so,
Right.
so let's pause my motion for a second, and we are I am gonna make a motion to continue this for purposes of making deliberations one last time. I know that we are, so there's no motion on the table just quite yet. Ahead of a formal motion, I know that we are somewhat bound by, not somewhat, we are bound by a backstop of time. We are not married to a Tuesday meeting, although we have August 25. We can't do 9/1.
No, Mass General Law says the zoning board of appeals can't meet on, a primary day.
Oh,
Is
okay.
it September 1 or September 8 is the primary day?
The primary date's the
That's
first.
the first?
The first, okay.
Okay, so that limits us to,
I don't know if it says any meetings or
can we
just
meet-
hearings.
Yeah.
Can we meet
Is it any
another day?
meetings or hearings?
of
yeah,
the
yeah, we
date?
can meet anytime that works, but I want to figure out a date that works. If we're thinking of Tuesdays, we obviously have next Tuesday, the 25th. We have September 15, and we have September 22nd, which still puts us within the time frame that we have to render a decision here. So I don't know if there's any preference. Obviously, there's a lot for us to look at and digest, but I don't know if there's a preference amongst the attorneys as to whether or not 8/25, 9/15, or 9/22 works. If any of those three dates works, we can try to lock it in. I know that the 15th is a regular scheduled zoning board hearing that we have, 3 hearings on, so I would hesitate to really, I'd rather devote the time for this to us and us alone versus, people coming in for ADUs ahead of time, or what have you. So.
I would say the 25th because I
The
think the
22nd, you
fresher.
mean?
The 25th, next Tuesday.
Tuesday.
The 25th.
I'm just out of town. If you need me, I just couldn't.
Yeah, that's
attend,
problematic,
but
because I would like you to be here.
Are there any dates that are good for you other than
The
these
rest of
days?
those are fine. I'm just out of town next week.
Other than a Tuesday?
What about a non-Tuesday?
Yeah, I could do, I'm out all next week, but other than that, we could do, it doesn't have to be a Tuesday.
All right, gentlemen, do you want, is there, as you're both everybody's looking at their phones, is there a date
Why
that,
can't we do the 8th?
September the 8th?
Yeah.
I don't know the answer to that question, aside from, I think I have a conflict, so that's, what
Okay.
is it, Labor Day is
Okay.
Monday, the 7th?
Correct.
And
What
then,
about Monday, the 31st?
let me see. Let me put it up before I ruin everybody's hopes and dreams. Does 8/31 work for you guys? Or, and also Chris?
So, Mr. Chairman, just speaking for myself, it's not clear that I'll attend, and so I certainly am not going to hold up other people if everyone's available on any of those particular dates. Since the portion of the public hearing where I could participate is concluded, I'd just be an observer. And so please proceed with whatever date works best for everyone else.
Brother Brodsky, does 8/31 work for you? It's a Monday. Nobody wants to do anything on a Monday, but we can do something.
But we can't do it Tuesday is the problem, so.
Right.
No, I would pick the earliest date that you have available, please.
Can I ask a question?
Why not?
Why can we not deliberate tonight?
Because I said so. And there's a tremendous amount of information that we need to digest and involve counsel. So I mean that in the most respectful
Sure.
way.
So 8/31's not good for me,
Okay.
but I could
What
do
about
it
the rest
later
of
that.
that week, 2nd, 3rd, 4th?
Yeah, I could do the 2nd or the 3rd. It's a
Second or
Wednesday or
third?
Thursday.
Second or, let me see
The
here.
2nd's the first day of school.
So,
Who cares?
I'm just letting you know.
Yeah. Let's see here. So the second,
We don't have to meet here.
we can meet back in the,
Yes. Well, the select board,
The 3rd is less good for me. The second, a Wednesday, I mean, not ideal, but certainly we could pull that off on September 2nd, or alternatively, I don't know, the following week in September. I'm gonna be away, the 9th through the 11th.
What, next week?
He's not here next week.
You're gonna go on the whole week?
Yeah, he's on,
what about Thursday of this week? I know, it's not Thursday of this week?
Thursday of this week?
We don't have time to post.
Right,
How much time do we need to post?
48 hours.
48 hours.
okay, yeah, so,
We can meet at 10:30 on Thursday night.
Yeah.
no, here's what I would suggest, is, like, what the, this is killing me here,
We're
so,
all against weekend meetings.
right, I know.
I'm here.
So I guess, for lack of a better option, it could be either Wednesday, September 2nd, or Thursday, September 3rd. Selfishly, I have a deposition in Webster, Massachusetts, at 10 a.m. on Thursday, September 3rd. Doesn't mean I can't, get less sleep the night before. So for the benefit of everybody, to include you, sir, like, I get it, does Wednesday, September, what do we put?
Second.
September 2nd work?
Renee, do you think we can get this room?
I
Because the selectmen are meeting at the town hall that night, right?
I don't know where if we would be able to meet here, or, and I don't know if the select board
Is there another room
meeting
at town
on-
hall?
Yeah, it's
we
an
can,
upstairs
upstairs
disaster
room,
room.
we could potentially meet, in the library in this building, or the large group room at the middle school. Those are,
Whatever you can find out is available.
the large group room would probably be my second choice.
We don't necessarily know this room isn't available.
Yes, we don't know that this room is not available.
And then alternatively is the week of September 14.
That's terrible for me.
Okay, then,
I'm not a voting member, but
right.
let's do
Terrible.
the second.
How about September 2nd?
Again, Chair Hennessy, please schedule it at your earliest convenience.
Okay. For the benefit of everybody's well-being, let's go with September 2nd. So what I will do now is make a motion to continue this hearing for purposes of deliberating to whatever date that is.
September 2nd.
Wednesday, September 2nd.
Wednesday, September 2nd, 2026, at 7 p.m. Location to be determined, but preferably right here in the exhibition room in the high school. That is
That
my,
will be noticed.
and that will be noticed. So that is my motion. Do I have a second?
Second motion.
Okay, so motion by Hennessy, second by Parsons. All those in favor, roll call vote. Aye. Aye, Hennessy.
Aye, Parsons.
All right, we are complete. Thank you, everybody.
Thank you, good night.
So motion to.
And now I'm gonna make a motion to adjourn.
Second.
All right, so motion by Hennessy, second by Rogers. All those in favor, roll call vote. Aye.
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 Aye. All right, we are adjourned. Thank you, everybody, very much. Thank you, Hall TV.